Hello, good morning, and welcome to Newsfile. I am Samson Ladi Ayenini. This morning, I have a simple but difficult and almost criminal job. Well, don't get worried at all. I am only going to try to steal the job of the sole commissioner for judgment debts as I continue the cross-examination, but here of willing witnesses in furtherance of the public interest on the Drillship drilling dribbles. It's no joke when a UK-trained barrister and an outspoken politician literally weeps under cross-examination over this matter. It is a strictly facts-only discussion on the issue today. So you're welcome. The central bank says 40 is fortified. Shall we shut up now? We'll get into that one as well. And what can we expect from the Professor Dateba WikiLeaks probe as it invites all parties over for lunch? Well, when we make time, we shall also try to discuss Parliament's intervention in the battle between Tobinco and the drugs regulator. I'm Samson Ladi Ayenini. You're welcome to Newsfile. This is your most authoritative news analysis show. We'll be right back. I'll introduce my guest and we will get into the details of the discussion. You're welcome back to the show. And this show is coming to you live from Multi-TV Studios. This is your Joy News channel. It is also on Joy 99.7 FM, Love 99.5 in Kumasi, and more than a dozen affiliate stations across the country. We are live on ABN TV, Sky Channel 290 in the UK and elsewhere in Europe. It's streaming live at myjoyonline.com and multitvworld/streams. Thank you very much. This show is always, there's a repeat telecast at 9:30 this very night on your Joy News channel. Now, my guests are seated and we're just about to start with the discussion. Always know that your views and comments and questions are welcome. 1422 is the text line. You can post your comment also on our Facebook page on our wall, and we'll share them with those who are listening to us all over the world. You can also send your comments to Newsfile at myjoyonline.com. My guests who are seated now in the studio are Abdul Malik Kwekubako Jr., who is the editor-in-chief of the New Crusading Guide newspaper. We have Clement Apak, Dr. Clement Apak. He is a presidential staffer. We have Dominic Nitiwo. He's a deputy minority leader in the legislature. We'll be joined soon by Ernest Kofi Abochi. Is a senior lecturer at the Gimpa Law School. Good morning, gentlemen, and welcome to the show.
Yeah, good morning.
Thank you.
Right. This morning I want to codename all that you're going to be hearing as the strictly facts-only discussion. Sticking to the facts. And let's see how we can help the public to appreciate the issues that have been very topical and which we are discussing. We are discussing the Drillship matter. We are discussing 40s, Merchant Bank. We are discussing also Justice Dateba's probe, the panel. They've invited Sir John, they've invited as the General Secretary of the NPP, Kojo Usefrie. They've invited Victoria Hammer, former Deputy Communications Minister. I'm sure that the same sermons would have gone out to Nana Oyeleta, who has been mentioned in that infamous tape. Well, And you may be aware also of Tobinco having problems with the Food and Drugs Regulator, the FDA. Now, Parliament made an intervention and called for a ceasefire and for some other things to be done. We will also get into those issues, and we're hearing actually from the ministry that the FDA doesn't have the power to shut down any pharmacy, really. We'll get into all of those matters, and those are the matters for which we invite your comments. Now, let's first go to the sole commissioner on judgment debts. Let's go there and take a listen to the two former minister and deputy minister, Kandapar and K.T. Hammond, and then we'll also listen to the former GMPC boss, Tsatsu Chikata. They were both at the commission, and they gave their evidences or testimonies about what's led to the debts and what happened to the balance of $3.5 million.
My Lord, where is the $3.5 million? I've said that the amount retained in the retention account was $900,000. The sum of $100,000 was used to pay legal and minor incidental expenses by the lawyers, not by K.T. Hammond. My Lord, the balance of $3.5 million was paid by Barclays Bank bankers draft number 01953801, dated July 18, 2001. The check was subsequently paid to the account of Government of Ghana. The check, a photocopy of which had been given to me at the time. But the original check was given to Ambassador Podo, the High Commissioner. And it was the High Commissioner himself who arranged, with instructions from the Minister of Finance, to pay it into an account at the Ghana International Bank. And, my Lord, I have here a copy of the check. Not only a copy, it's a return check. You know, in UK there is this tendency for the bankers to return your check to you after it has been paid. And I do know all that happened with that account, with that money. It was duly paid into the account of the government. My Lord, what then happened to the $3.5 million thereafter? My Lord, I never was the Minister of Finance. I wasn't the Accountant General. I wouldn't know. I think the Accountant General should be called here to tell us what happened to the money. You know, because I do know also from here that the Ghana International Bank subsequently paid the check into its account at Chase Manhattan in New York.
My Lord, I intend, by associating myself with my minister and the evidence I'm also going to adduce, to demonstrate that the sale was transparently done, was scrupulously done, and there's nothing untoward that happened.
There are people in this country who will have the information about where the 3.5 went to. Now you worship your God and you pray. God will not let you down. I went to Parliament the other day. When I got in there, I had a document in my pigeonhole. Hand it over to His Lordship. My Lord, this document has every document, every indication, who wrote a letter, who deposited the account where, who did what, the drawings on this account, the whatever. A young man came here from Bank of Ghana and said that he doesn't know, they don't know about anything. They know it in this country. My Lord, it's all here. 65 pages.
At the time that I left office in GMPC, that drill ship had clear value for the work of the corporation, and it was the objective of the corporation to continue using that drill ship. And it was also the objective of the corporation, where possible, to have the capacity of that drill ship expanded. Now, from the Minister of Energy's press conference, the former Minister of Energy's press conference at the time, some negotiation was undertaken and a value set for the drill ship. I don't know how that value was arrived at. I cannot, and I cannot imagine that you would get the best value for your asset if you allow a bank to go and take a judgment by default on the asset. And try to enforce it against the asset. You allow the default judgment to happen, and then they start looking for enforcement mechanisms and looking for assets. Clearly, a distressed sales situation would not be the best context in which to realize the value of the asset. I cannot see why, from any sort of national perspective, why it would be better, even if the government wants GMPC to do things differently. It's not clear to me why it is better for the minister or the deputy minister to be the one to be selling assets of the drill ship, such as the drill ship, which they know very little about, and they have very little understanding of how to get the best value.
All right, so you heard Katie Kandapar, who is the former Minister of Energy in the Kufuor regime. And then you heard also his deputy then, Katie Hammond. And then you had Tsatsu Chikata, who was GMPC's boss before the Kufuor administration took over in its first term. Now, I'd like to start straightforward, and I'll go to Abdul Malik Kwekubaku Jr. I'm sure you have followed him, and you understand why I'm going to him, because he seems to have the documents that Justice Apal, the sole commissioner himself, is surprised how he has gotten all the documents. And the key characters who need these documents to speak to didn't seem or appear to have the documents. The sole commissioner, its central aim is to check if the judgment debt was justifiable and unavoidable. Is to check whether or not there was a just debt to be paid, whether the payment was unavoidable, whether the amount paid was reasonable, and whether or not due process was followed. And more importantly, so that the nation will not get to repeat such situations anymore. Abdul Malik, as brief as you can, and strictly on the basis of the documentary evidence available to you, can you take us through a brief narrative, point by point, of what happened and led us to where we are?
Well, interesting point. It depends on how you want it done.
Right.
If we were to proceed from the good old late Professor Mills's theory of genesis of the liability, we could capture that in a certain distinct context. And I believe it was within that context that Mr. Chikata was invited, though I don't think the investigations or interrogation was thorough enough. And if you proceed, you can also leave that aside and deal with the effect, the payment of the liability. What happened there? And that's why I want you to guide me.
For the benefit of those who have been following and don't seem to quite, appreciate all that is going on, we are interested in both sides.
Interesting. Yes, I wanted this guidance so that I could deal with it properly. So we go to the so-called genesis of the liability.
That is so.
That is founded or rooted in the hedging transaction that the GMPC entered into with Societe Generale.
Right.
I'm told I don't pronounce it well, so I'll subsequently be saying SG.
Right. Societe Generale.
Yeah, to spare myself any ordeal. So that is it. It began in October 1996. It was a hedging process, very complicated one, at least to my lack of professional understanding of that market. But it was founded on the fact that we were going to produce oil in the future, targeted at January 1998. And Mr. Chikata describes that as selling future oil. Somehow, things were going quite smoothly till somewhere 1998 when things started going wrong. So complications occurred there, and Societe SG began to negotiate deals with us as to how to secure their interest and investment in this whole transaction. That led to the Drillship being collateralized. I have the documentation here. And then some other documents signed, we admitting that we owed them at that point in time $40 million. That was about it. By 1999, early days, 1999, GNPC had not been able to fulfill those obligations, those that we had signed on to. So SG decided to proceed to court and initiated legal proceedings. The board of directors of GNPC was duly informed about this. They approved the need for the GNPC to put up a challenge based on a document that the chief executive had presented. So the litigation began. Interestingly, while this litigation was going on, there was also a parallel level of settlement negotiations. So they were going on two levels. They were in court battling the issue. At the same time, there was that presence of mind that, look, we could settle this matter out of court. So it was going on at the same time. Then there was a change in government in Ghana. Election 2000 resulted in a change in government. So the new government took a decision that it would not pursue the litigation any longer. That is the case in court, but was settled for the negotiating aspect.
Right.
Whilst this was going on, 6th June, and we go by the figures, but before then, let's note that cabinet, the Kufuor cabinet, on 8th May, had decided, and this is the memorandum to cabinet on subject. The subject is disposal of GNPC's current drilling rigs and marine assets, submitted by the Minister of Energy, dated May 8th, signed here by Albert Kandapa. This document shows that government decided to dispose of the marine assets and the rigs, though the only asset that they considered as having had some good use was D511. It's all documented here.
Right.
Subsequent to this came the judgment, the default judgment. So at least there was judgment,
Right.
albeit default, dated 6th June. So that's it. Around this time, you had the Baso, and I'm sure I haven't pronounced it well, Baso Offshore Consultants, working with New World Investments Limited. I'm sure everybody knows who they are. It used to belong to Kwampini. They were fronting or acting for frontier drilling. This group goes around the world. They are specialists in looking for rigs for people to buy. Came up with some offer for 20 million for the rig. So that's here. Then you have the situation had moved on. We had default judgment. Government had decided Katie Hammond was dispatched on June 13th from Ghana in his capacity as Deputy Attorney General and Minister of Energy to go and negotiate a settlement. He did. 3rd of July, the Attorney General effected power of attorney through the GNPC. All the documents are here. You have the power of attorney, which was signed by Oforikwa, witnessed by Osla Owusu Ajay and Mrs. P.J. Donton.
Oforikwa had taken over from
He was acting
Tsatsu Chikata.
Yes.
Acting.
That thing, there's a gray area. I was wondering, was Asafo Ajay not there before Oforikwa? let's determine that. Because I recall, if my memory serves me right, that Oforikwa took over from Asafaje, who came back recently. Yes, so there was somebody in between, Chikata and Oforikwa. But Oslaje, as special assistant to the Attorney General, signed as a witness. Oslawusu today, our member of Parliament. Then Mrs. P.J. Donto, Chief State Attorney, also signed. Then you had the resolutions of the GMPC signed by Oforikwa, all dated 3rd July. Then you have a certificate of authentication signed by the Attorney General himself, Nana Adodankwa Akufo-Addo.
Right.
All this dated 3rd July 2001. Before then, of course, since Katie Hammond left 13 June, they had entered into a memorandum of agreement dated 20th June 2001 relative to the sale, the negotiations to sell. The other fact is that there was then 9th July, the settlement agreement between the GNPC and Societe Generale. This is the settlement agreement. The same 9th July, whilst this settlement agreement was being done, there was a joint application by SG and GMPC, represented by Katie Hammond, at the Oman court, commercial court in Oman. The joint application was to seek the release of the D511 from precautionary arrest and detention in the jurisdiction of Oman. That's it. Then document number 10 here is an addendum to the memorandum of agreement dated 20th June. This memorandum, addendum, indicated how the monies should be paid. And it says further to clause 3 of the memorandum of agreement, that is the 20th June one, it has been agreed that payments shall be made by way of one payment letter in favor of SG in amount of 19.5 million and one payment letter in favor of Constant and Constant in amount of 4.5 million. 2, $900,000 US shall be kept in escrow between sellers and buyers on the client's account of Constant and Constant on terms as described on the attached solicitors undertaking from Constant and Constant, dated 10 July 2001, London, 10 July 2001, signed by Katie Hammond and one Martin Lond Martinsi. I'm sure I pronounced it wrongly. May I be forgiven?
Don't worry.
Some of these names are strange to me. And then witnessed by Anthony Barton, Constant and Constant. That is document number 10. Then, interestingly, July 16th, then Knox Bank, the bankers of Frontier Drilling, the buyers, issues a payment order in favor of Societe Generale, $19.5 million. Amount, the value date was 16 July, beneficiary Societe Generale. I need not go into all the details, it can take too much time. But this is document number 12. Then you have number 11. Then number 12, you have the payment order to Constant and Constant. Same details from the same bank, $4.5 million. Then, of course, this is a letter from Constant and Constant to Frontier Drilling on those things I've just discussed. But attached to it significantly was a Ghana National Petroleum Corporation list of its related creditors as at 30th June 2001. All the creditors who had to be paid. It's all put here. And it came from GNPC and nowhere else. Then you come to the part of when the sale had been effected, monies had been transferred, and what was going on. This is temporary receipt. It is from Acting High Commissioner Chris Kodo. It's very short, so I'll read this one. He says, this is to acknowledge receipt from Honorable Katie Hammond, Deputy Minister of Energy, the sum of $3.5 million in Barclays Bank check number 01958853800, pending further instructions from the Honorable Minister of Finance, London, dated Friday, 20th July 2001. Then the pigeonhole document, a copy of which was dropped at my office by a motor dispatch driver, whose identity I will not disclose. I've subsequently found out, but I will not disclose.
Miracle document that saves Katie Hammond.
Yes, sir.
Wouldn't it help to disclose the identity?
A journalist, I will kill the profession if I did that. I see. And you know that. I will not just kill myself or my paper, but I'll kill the entire profession. the very moment I do that.
Even if it is going to help resolve
I
the
will
riddle.
go to jail rather than disclose. That is our job.
Could
I
we
respect
proceed
that.
and briefly
This is
finish
final.
with this point?
No, this is the last.
Yeah,
This is
right.
the last one.
But Samson, I think that if Kuku goes with this one to help us,
No.
I'm
We'll
amazed.
just take your time.
This one.
We're doing the.
This one is dated 25th July. Don't forget that the check, a copy of which is here, was dated 18th July. Now, this is a letter dated 25th July.
From what you're holding, our original document.
Yes, but you can bet.
Serious.
We can bet that this is our work. You are part. You know this job. You've done some before.
See the way he's holding the documents. It's like we are in an exam room. He doesn't want me to see.
I've got a few photocopies, and I even think that the source may be from him. Okay, move on.
This is dated 25th July 2001. It's addressed. It's from the Ghana Office of the High Commissioner for Ghana, addressed to the manager, Ghana International Bank. And it says, dear sir, opening of account, Treasury Officer Special Dollar Investment Account. Please open an investment account in US dollars for the Ghana High Commission, London. The account should be designated Treasury Officer Special Dollar Investment Account. Address the Treasury Officer, Ghana High Commission, so and so and so. Advise this office as soon as the account is opened. Signed, Emmanuel Bani, Treasury Officer.
Right.
There are a few comments down there. Then, the following day, 26 July 2001, a letter comes from the bank addressed to the Ghana High Commission. It says, attention, Mr. Bani. Rear, account number 1011-91613. We wish to advise you that we have opened a U.S. deposit account in your name at this office, to which we have allocated above account and have sent for collection your banker's draft for $3.5 million. The above account number should be quoted on all correspondences pertaining to this account. Yours faithfully, Mrs. L. Buama, Assistant Manager, Retail Banking Department.
Right.
I won't read, and this is it. This, you remember, I had brought this check,
Right.
this transaction document here way back, and we published it way back. This shows you the check. It tells you GIB placed it, received it as a paid to the credit of the payee's account with GIB. Then they routed it through Chase Manhattan Bank. Let me repeat, Chase Manhattan Bank, because people are asking that where did that come in from? Where did I go and bring that? But that is here. It's on the document.
Okay.
Also the transaction, original transaction document, in the name of Ghana International Bank. Because see, you'll be surprised. It was an investment account, so they were accruing interest too. And from this page to the page 65, you will see withdrawals and disbursements, most of which went to GMPC. Then another one went to A.J. Walters to do with aviation. I suspect Ghana Airways matters. I haven't done my double checking.
Okay.
And then some few odd withdrawals relative to what is described as salaries to the Treasury Office of the Ghana Mission. They need to come and explain.
And
Let me
finally,
put on
the
record.
letter that closes that account.
It's here. I'm sorry. I nearly did something. See, this is it. This is dated 12 December 2005. I refer to our letter number so and so and so. I don't need to read those things.
Right.
Authorizing you to close. No. That's it. Transfer of funds, 14th October 2005. You are authorized to close the accounts listed below and transfer the balance into the Treasury Officer's account number so and so and so. Treasury Officer's account number 000119116.
3 accounts, including this dollar
yes,
account.
but the first one is the dollar
Right,
account.
right.
And that was left with £1,008.
Okay.
78 pence. And you remember, we discussed here, and I was surprised that the Controller and Accountant General Official went to the Commission and made this disclosure of account having been closed, but did not back it with statement of accounts. I thought that was an oddity.
All right.
Because it just created room for suspicion. Now here we are, every single withdrawer, every single one is here to the very final day.
Okay. Koku, thank you very much. You hold on there for us, and then we'll go around. We'll come back. We'll be dealing now with looking at these documents in further detail and juxtaposing the facts that we know so far with the testimonies that were given at the Judgment Death Commission's Sole Commissioners, Forum. I need to let you know that this show is brought to you by the kindest sponsorship of MTN. Everywhere you go. Errata Motors, the best deals that you can get in vehicles, and Star Assurance, that is your best insurance company, Vital Mineral Water, and of course, Lipton Tea, inspiration flowing from nature. I need to tell you, more importantly, that if you're looking for a new or slightly used car, you certainly should try Errata Motors. And you can find them at Lagos Avenue opposite Body Talk near the GT Bank, East Legon. You can call them on 0244 445 268 or 0247 486 800. That is Errata Motors. They have Mercedes-Benz, Toyota, Infiniti, Range Rover, and you name it. And Star Assurance wants to remind you that now they are not making a joke out of the General Insurance Company of the Year award of 2012 that was bestowed on them, and the fact that they are privileged to be the General Insurance Company in the Ghana Club 100 rankings that they also chalked. They were above all other insurance companies in that ranking. They are promising you that they'll continue dedicated services to you to offer you cutting-edge insurance policies that give you peace of mind and power to achieve your set goals. So they have branches all over the country, and they invite you to talk to them at Star Assurance. The number is 0302 240 632, or you can visit them at starassurance.com. Star Assurance, that's your CIMG insurance company of the year 2012. Star Assurance, that is certainly your solid partner. Now, Doc, the narration that I sought to get Kuku to help us with, dealing with the facts as we know them or as evidence on the documents that are available to us so far. I'm sure that you are familiar with some of them, even though there are portions that he may not have had the opportunity to capture. And this was supposed to be very brief, really. If there's a portion that you feel you need to highlight, you have the opportunity to do so. But if we can now go into the Commission's, platform. You heard Kandapa, you heard Katie Hammond, and you heard Tsatsu Chikata. What conclusions have you made in the end?
Well, fair question. And let me say good morning to our listeners and viewers. It's been a while since I've been on the program.
Good to have you.
And it's always a privilege to engage in these very important conversations regarding how best we can move this country forward. But I think before I start my submission, it is very important to state that whilst I was the convener for the Forum for Governance and Justice, we led the crusade in calling for a commission of inquiry to be set up to look at why and how a developing nation like ours had to dole out in excess of 600 million Ghana cedis in paying various forms of judgment debt. And I remember that the late former president, of course, I'm speaking of the late President Mills, may his soul rest in peace, had expressed similar concern. Be as it may, the good Lord did what he had to do. He was called to glory. And so when President John Dramani Mahama took over after the late president's demise, he went on to, if you like, on the basis of the strength of the Constitution, institute the sole commissioner to look into the issue of judgment debts with very explicit reasons, one of which includes for us to know where we fell short, the circumstances and conditions under which these judgment debts have occurred, and if possible, to take the needed corrective actions and measures and to provide us avenues to shape policy in a way that will prevent these kinds of losses to the state from occurring. So I think it is very important that we put this into perspective. And the president must be given credit for making the move that he did. And so it raises a lot of questions as to why some have tried to personalize it and to even suggest that the institution of the sole commissioner was essentially to achieve political equalization, or if you like, to witch hunt. And I think that it is very important that we dismiss that in totality and look at it purely as an exercise that is warranted given our recent history and to forestall these types of occurrences from going on. Now, having said that, I had a chance to listen to those who have appeared before the commission in as far as the three gentlemen are concerned. And I think that the issues are very basic as far as I know. One is whether the sale of the drill ship was justified. And two is how much was paid to SG. And of course, three is where the check from the buyers went. And of course, what has happened to the remaining 3.5 million that was the remnant of the total amount of sale. But it is very curious as to why a potential agreement or a settlement for just 14 million would have ballooned into 40 million.
Right. Let me now introduce Kofi Abochi. Good morning and welcome to the show, sir.
Good morning, Samson.
Right. I had already introduced him and he just got here. He's had to do some bit of sacrifices to be with us, and we appreciate that a lot. He is a senior lecturer at the Gimpa School of Law. Continuing with your point, you are surprised that some payment that was supposed to be initially $14 million would have jumped to
40 million.
40 million.
Yes. Well, so as I was saying, it is a very curious point to ponder over and to consider. Particularly so when you had a situation where there was the possibility of, a settlement, as Senior Comrade had indicated earlier, and that the state indeed had entered into some litigation, and you had a change in government, and the new government then decides that it was better to, withdraw the litigation and to proceed with the negotiated settlement, which then allowed those who had brought this action or made this claim against the state to get more than the 14 million Ghana cedis, dollars. And I thought that the statement was very revealing. Particularly, it came from the then Minister for, I think it was Energy, Kandapa, right. If I'm right. He said that very clearly. In his statement, if you looked at his testimony, he stated that there was a possibility that we could have paid less in terms of the settlement. So I think that is an area that raises a lot of questions, and we still need to understand what the circumstances could have been, which informed the need to withdraw the litigation, which caused the new government to forgo the possibility of settling for less.
They didn't actually withdraw. They are being blamed for not pursuing the court process that was ongoing.
Well, rightly so. It raises a lot of questions. What is the motivation?
Because there's actually the suggestion that if there had been a formal withdrawal, things would have been better, really.
That is exactly the point. And I think we
interrogate that shortly.
This is part of the purpose of this whole, investigation. There has to be good reasons. And then you look at the fact that all of these transactions took place, and we have no record of somebody from the GNPC being a part of it. And it is even more curious when you think about the fact that all of this was also done with the power of attorney, which was granted to the Deputy Minister for Energy at the time. So there are a lot of very serious and curious questions that need to be answered. And I actually reject your earlier premise that, with all apologies to Senior Comrade, that what he's stating are the facts. We can never truly know the facts until this investigation is over. I think what we are dealing with
I refer to facts pertaining to the documents available to us so far.
I know, but even the authenticity of those documents can only be established by the sole commissioner.
Until and unless you successfully produce documents that suggest otherwise, these are the documents that we
No, but you are a lawyer.
follow.
Can you vouch for the authenticity of those documents?
I have looked at those documents.
The point I
have looked at those documents, and in the absence of other documents to the contrary, they are the documents I'm sure the commission will work.
Yeah, but we cannot be certain that there wouldn't be other documents.
The commission has them.
That is the point I am making.
A point of information. That pigeonhole document, the Controller and Accountant General has it.
Right.
And indeed, when they appear the next time, they have to present it.
Well, we would surely find out. But the point I am making is that we cannot take what others are saying as sacrosanct, and we cannot vouch for their authenticity until otherwise confirmed by the sole commissioner. But be as it may, I think that, this is only a tip of the iceberg. There's a lot more that we are to learn. But let nobody suggest that the work of the sole commissioner is witch hunting, and that the sole commissioner has been generous, or if you like, has pampered persons who have appeared before him. And look, this is all about our nation. It is about our future. It is about identifying where we are falling short. It's about our accountability. And we should see this as that. This tendency to try and malign the sole commissioner or his work simply because, some people are being put under the spotlight, it's not very useful.
People felt, those who support the argument that you disagree with now, say that if you look at the manner in which the process went, Kandapa and K.T. Hammond, or especially K.T. Hammond, appears to have been treated as though he was an adverse witness. And the commissioner and the commissioner's counsel, particularly, sought to interrogate him, cross-examine him in such a bit of a ruthless manner. But when it came to Tsatsu Chikata, he didn't seem to carry the same posture. And that's their problem.
Yeah, see, I disagree with that. And I think that it is only reasonable that those who were active in the theater, I'm using military terminology here, quite clearly had to be examined much more critically to verify. And if you can look at their statements, they all, at the end of the day, agreed, even if in a very subtle way, that most of what they undertook came from above, and that the then Attorney General was very central in the whole process.
Right.
And therefore, some of us are looking forward to Mr. Akufo-Addo being invited, because, he has a lot of questions to answer. Seriously. And let's not belittle the issue and to reduce it to the usual NDC,
on the top of your mind,
propaganda.
On the top of your mind, what one question do you think Akufo-Addo ought to be answering at the commission?
Well, I think that one question that I would like to hear him answer is to justify why he decided to withdraw the litigation that was going on and the processes that may have allowed us to settle our indebtedness to SG for less as compared to why we ended up paying the $40 million, which warranted, or quote-unquote, 19, which quote-unquote justified the sale of the Drillship. And from the testimony, or if you like, the statements that were made by Tsatsu Chikata, there was really no need for us to have given away such a very important national asset for the peanuts that we got. Totally unjustified.
Interesting. Now, Dominic, you also watched, and you see, I started my question with him on a sort of, a general perspective to give you the opportunity to be able to decide which particular facts you want to interrogate. You also watched, and I'm sure you may have seen some of the documents so far. What do you say?
Some. Let me greet your listeners and your viewers. The work of Parliament has taken much of my time, so most times, past the back, I've not been here. But it's nice to be back again to discuss with very great minds on this program. But let me concede that I'm amazed at Kwaku Baako. I think that this country should make good use of him. Seriously. We really, really need to make good use of him. His abilities are amazing to me. In many countries, they would have really found a better way of using him than we are currently using him. But I think that the questions that the average Ghanaian will want to find out are very, very clear. The documents he has presented, and because there are no alternative documents, and nobody has come out ever since these documents were presented to say, well, they are not true, or we are challenging the authenticity of those documents. I will presume they are authentic, they have been signed, names have been mentioned, the signatories have been mentioned, they have never denied it. Ambassador Chris Kpodo is around. He was a deputy minister until 2000 and of Foreign Affairs until 2012. He's in this country. So it's clear that nobody is disputing these documents. So the authenticity is very clear. Otherwise, the deputy minister should have by this time come to say, no, these documents, I have no knowledge about. He's not done it. So I believe that whatever is in these documents are clear. First of all, was there a debt to this nation incurred by GNPC as a result of the derivative arrangement that he had with SG? Some will use the word gambling, of course, for the average Ghanaian to understand. Yes, there was a debt. The document he has quoted clearly shows that there was a debt of close to about $40 million. Now, we are made to understand that there was an interest element of it. You see, when you owe somebody over a period, interest bills. If you go and owe a bank, I can tell you I owed a particular bank because I needed to take money to look after my constituents. And at the end of 4 years, I ended up paying close to twice that amount, 100%, because the interest was compounded. So if you owe somebody 40 million, you allowed that to build, 7 million, I can tell you, it's because it's dollar, it's small. So it rose to close to $47 million. So it's clear, it's established that we owed SG, clearly. Tsatsu, the deputy minister, and the minister, that's Kendapa, K.T. Hammond, and Tsatsu, all conceded that there were two processes leading to our dealings with SG. Litigation, and at the same time, the negotiation aspect. Let's sit down and talk. Let's sit down and judge all. So, at that time, government was doing both. That's the NDC government. But you remember that at a point, Rawlings had to fire Tsatsu Chikata. He never really concluded his term of office. He had to leave at a particular point. That's how come he was saying that there was somebody between Kwa and Tsatsu, which is true, because Tsatsu at a point had to leave. When the NDC was leaving office, Tsatsu was not the GNPC, the head of GNPC at that time. So it's clear that, yes, there was a debt. Whether we needed, the new government had to take a decision whether to continue with litigation or to go for the settlement aspect. What the then Attorney General did was to invite Tsatsu, and he conceded that he invited him. He looked at it, put all the facts together, and decided that in the interest of the state, that was his professional advice. Unless you are questioning his professional advice at this time, that in the interest of the state, we would rather pursue the settlement aspect. Because from Tsatsu's own argument, his argument was that, well, these were advisors, SG were advisors, transaction advisors, and they misled me. That's what I understood from what he said. But you see, when you go to a bank, they have the commercial aspect, and of course, they have advisory aspect of every bank. Every bank has its departments. When you take a loan from them, and their advice leads you to a bad judgment or bad debt or bad investment, you will not go and say, well, because you owe that bank, you are not going to pay. You will pay. You are a lawyer. I did law, but I'm not a lawyer. But I can tell you, you will pay if you go to court. If you use that as the basis of your defense, you will lose in court. And so
Tsatsu is concerned that when he had the opportunity to brief Nana Addo on the developments, he feels that if his point of view had been pursued, would not have gotten here.
You see, that's Tsatsu's point of view. Nana Addo did not consult just Tsatsu alone. He had other people who were involved in it, and he consulted them. That's Tsatsu's view. But trust me, as a professional lawyer and as the Attorney General at that time, he felt the best thing for Ghana was not to pursue the court case. And of course, he's the best person to answer anyway. And I think this whole brouhaha... No, I think this whole brouhaha that we are not pursuing this matter is just because people want Nana Addo to appear. Of course, he's a gentleman's gentleman. He will never run away. And he will be willing to appear anytime that they call him. I can assure you that. But I'm just saying that was a professional advice that the government took. From the cabinet memo that Kuku read, it was clear the government took the decision that let's not go litigating, but let's go for the settlement aspect. Now, you have a 47 million debt. You have a chance. You will manage to beat down during the settlement to 19.5 million. Or you could go to court and challenge the 47 completely. You could lose. Now, you are not sure whether it's going to take 1 day, 1 year, 10 years, or even 20 years. Meanwhile, the interest is building. So a lawyer needed to take a decision. The government took the decision at that time. So it's very clear that there was a debt, a decision was taken, and then 19.5 was paid, leaving 3.5. Now, I think we should not be shifting goalposts. The idea, where was the 3.5? Documents have been adduced to tell exactly where that 3.5 went. Remember that Chris Podo was not the government appointee. A government appointee, in that case, would have been the ambassador, the high commissioner in London. And that was Isaac Osei, Honorable Isaac Osei, the current MP for Sumi. He went, all this happened in August. He went somewhere in September, 3 months after, or in July, and he went somewhere in September of that year. I can tell you on authority that when Honorable Chris Pedo picked up that check and they paid, as you can say, up to today, never got wink or never got any to know about it, that 3.5, even though he was the political appointee. So questions should be asked to the then acting high commissioner, who is Honorable Chris Pedo, who then became a deputy minister under Mills. When he paid in the money, what happened to the money? If somebody is doubting the documents that Kuku Baku is holding now, it is for him to come and justify how the expenditure was done, because he was the one who picked the money, the check.
I'm sorry. This is a rude intervention. I'm not sure he is the appropriate person. This is the Contralor.
No, I'm coming to that one.
Yeah.
Right.
He paid in the money, but he says the documents are not genuine. He never said that. He never said that it's not true. Now, the Controller and Accountant General is the key to our finances. He has to find out, especially the expenditure. Tell us how that money was spent if somebody is doubting what Kuku Baku and Katie Hammond is putting to the judgment of the commissioner. So the issues are very, very clear. We should not be delivering the point. We should not be running helter-skelter and shifting goalposts.
Okay.
There was a debt. Somebody took the decision to go and settle, reduce the debt from 47.
But it is also important to note, like Tsatsu says, that by the time he left, there was no judgment debt.
It could be true there was no judgment debt, but there was litigation.
There
was litigation. Yeah. Tsatsu himself agreed that there was litigation and that it could lead to judgment debt. It may not have led to judgment debt. Tsatsu himself agreed.
Litigation where there had been 2 previous ones which the GMPC was successful.
I think, Samson, it's very clear that the ship had been rented to a company working in Mexico. You don't sue both in Mexico and the UN when there was a third party involved. So the Americans said, no, wait and sue in Ghana. Or sue when the owner has the ship. Because you're actually suing Ghana. You're not suing the third company. If I come to rent your iPad, and somebody is suing and joining you to that suit, you should wait. When the iPad is with me, then you sue. That's all that was about the original 2 judgments.
That's interesting.
But I'm also saying something. I'm also telling you something that Tsatsu, even his evidence, agreed that he was negotiating. He's telling us that, well, the people were willing to take 12 million. If you remember him, say that. So he himself was negotiating around a certain figure. But you see, I just wanted to clear the 14 million that he put. Tsatsu never mentioned 14 million. In fact, the 14 million never came at the current judgment, the current hearing that they said, when they swore to speak the truth, nothing else but the truth. The 14 million came about because Kendapa had written a memo to the then president. You remember that in that memo, he referred to Katie Hammond as deputy minister nominee. Designate. He had written a memo to him to say that, well, I've met this gentleman who represents SG, and of course, it's clear that we owe them. Well, I've given him 5.5 million as what we can pay him out of the 40 million, but I sense that the way he's talking, they may take 40 million. That was a memo he wrote.
Okay.
But later, when the facts were brought, the gentleman said, well, I may have been talking around that figure, but my principals in France say no.
All right.
So I don't see the angle of the 40 million.
Thank you.
So I just want to let him know that the 40 million doesn't come here at all. It had nothing to do with the fact that, well, they were prepared to take 40 million and somebody then willfully sent it to 90 million. Not at all.
Thank you. Now, if I may start with Mr. Abuchi on this note, there are those who are saying that, what is Tsatsu talking about? You were negotiating a settlement yourself. That presupposes that you didn't believe in the strength of what was before the court, even though he tells us that affidavits had been filed in opposition to SG's claim. What do you say, legally speaking? Is that what it means? That when you are in a settlement negotiation, it is to suggest that you don't have a stronger legal position?
Well, thank you, Samson. First of all, it is not necessarily conclusive in that direction. Lawyers call that without prejudice. So sometimes letters are written among others, and you indicate the fact that whatever we're doing is without prejudice to this particular matter, which is before the court. So the fact that you might have started negotiation of itself does not imply that you are giving up on your case in court. But it does demonstrate, at least, that parties have a willingness to try an alternative resolution beyond the court. I think on this matter, though, what it does speak of is the fact that both sides of the aisle were negotiation or settlement prone, and therefore you cannot really critique either party. So one party cannot be allowed to criticize the other party for having attempted settlement out of court, because it demonstrates the fact that both parties believed in the authenticity or the need to actually attempt settlement beyond the court's adjudication.
And in our present, in our jurisdiction at the commercial court, for now, that is a compulsory process you must
It is a pre-trial,
attempt.
exactly. It is a pre-trial process which you must go through.
Okay.
So our judicial process itself recognizes the need for parties to attempt settlement in a manner which is over and above and different from the regular court process. And so, as I indicated, lawyers will say it is without prejudice, i.e., we're trying something, but it is without prejudice to our rights to still, go to court and litigate the matter through the regular process.
And that will also mean that the matters that you discuss at the settlement will not come into the trial if you go on trial.
No, you normally and ordinarily cannot use those in court.
Right.
First of all, they constitute an out of court information or evidence, and therefore, if you attempt to lead them per se, not only would a lot of the issues involved be deemed or classified as hearsay, but under other circumstances, parties may actually not be allowed to do that because it is bad faith in some circumstances. I should be allowed to be free and open-minded and make concessions that ordinarily I wouldn't make if I'm involved in a regular litigation or regular legal process. So,
right. Tsatsu seems to say that, look, we were pursuing the process in court, and your failure to go to court may have cost us the amount that we eventually had to pay. So that if you had been able to go to court, or you instructing the lawyers to stop work, also inured to our disadvantage. So that if you had gone to court to properly have the processes, struck out or withdrawn, maybe you would have paid a lesser amount. Do you appreciate that position?
Well, again, it may seem that the information and the issues are so complex. I'm sure there are still some things we probably do not know. The question is this: in the regular legal process and practice, the standard practice is for parties to normally announce to court an attempt at settlement if the matter is properly before court.
Right.
You don't just embark on settlement when the matter is ongoing and you don't tell the court. It's not a practice. Because what may happen is that if the court doesn't take cognizance of the attempts at settlement, and if one party fails to come to court thinking we are trying something out of court, the court may still go ahead and make pronouncements, and it may bind you. And you would not be heard to say that you were trying settlement alongside. So what parties normally do is to request of the court a suspension of trial while parties attempt settlement. And if you are successful at settlement, then you come back to court, you announce that to court, and usually that get adopted, and that is what is usually called consent judgment. So I'm not seized of all the information here as to whether that was done. Right. If that wasn't done, then I think there may be a certain lapse. And again, whether this may be symptomatic of the change in government, and whether or not one party probably wasn't sure of what has been announced before the court, or whatever information we had before the court. But those are other general issues, if you allow me, I actually want to speak to. You know,
but does it also matter that you don't inform the court? And you're saying when you don't inform the court, on your blind side, a judgment in default could be taken. But when you don't inform the court and you are successful at a settlement, you can still go to the court and say, we have settled.
The parties can still announce. If the parties are both agreed on the settlement, the parties can still announce to court that while the matter was ongoing, they attempted settlement, they've arrived at a settlement, and they wish that the court should adopt that. The court would ask them to come with terms of settlement.
How significant then is that point that seems to place a certain priority in the blame game, in saying that the non-appearance in court or the non-continuation of the legal process by the Attorney General, Nana Adodankwa Akufo-Addo, at that time, making sure that we had representation in court, may have affected the entire process somewhat. How significant is that, considering that if it was SG's claim that Ghana owed, or GNPC owed 40 million, and they got a judgment debt for 40 million, but that judgment debt was not the amount that was paid eventually?
Well, as I indicated, the standard practice is for parties to continue going to court until and unless the parties have agreed before court that they attempt a settlement. If they have, then even if one party goes to court, the court would not listen to the other party unless the court has noticed that indeed settlement has broken down and that the other party has been given notice that the matter is recommencing. So it is not standard practice for parties to agree on the site and for one party to just stay away while the court itself has not officially endorsed the fact that settlement is ongoing. As I said, I'm not sure what has been done here. Remember, and I think I would want to tie it in with the general issue. I normally don't want to discuss these things with particulars because the problems we have in this particular issue is symptomatic of a larger problem in this country. Okay. And I think it's important that we look at some of these things in a very global way to address the issues. Otherwise, we solve one, but we have a lot of these things pending. For instance, the Attorney General's Department is an institution. It is a person as per Article 88, but the department is an institution. And therefore, governments go, governments come, changes in between governments, the institution functions. Many of these things, even before we have new Attorney Generals, many of these things are designated to specific desks. Who was in charge of this? Was somebody specifically instructed to be going to court on this matter? Or was the Attorney General himself the one showing up in court?
There were external solicitors who were taking charge of it.
Right. And if there were external solicitors, what is the instruction? Who instructed them specifically to stay out of court? I mean, on this particular issue, I'm not sure that as far as this particular matter is concerned, we have the full facts.
Just 1 second. Koku, is it not a case born out of the evidence that it is the Attorney General then who decided to sever the relationship with the solicitors?
Bindman and partners.
That is so.
That's so.
Right, so you have the answer to that.
Right, correct. So then clearly...
So the lawyers went to court and told the court that we are no longer representing...
Right, then presumably one would expect that before that termination is done, there would have been a contingency arrangement. Who's going to stand in the meantime? Because otherwise, if you don't do that, the court process will still continue. Once, as I indicated, the court doesn't have a formal notice that proceedings should be suspended while parties attempt settlement. I think it may be in that light that probably we'll have to look at some of these things in a broader perspective. As I indicated, this may be just one isolated case, but we may have many of such instances in which the Attorney General's Department in Ghana, it happens. Very often there are issues of attempts at settlement, and the matter may go on, the other party may not show up. I think we have similar issues involved in the Waterville case, the famous, the so-called Wayome case. Right. Issues of settlement and the matter going on, and the parties taking
default judgments
beyond, exactly, among others. So I think that it's an institutional problem, it's a systemic problem, and probably the more we look at this from a broader perspective, the better.
The question a bit about that I was asking really is this: how significant is the non-appearance to the eventual outcome that we are faced with, which we are discussing now? If it is the case that Societe Generale was claiming 40 million in court, and they got 40 million in court. And then that judgment was compromised subsequently by the parties, and we pay 19 million.
Right. I mean, you can always compromise on your rights in respect of judgment. So if they got a higher judgment in court because of our absence or our failure to defend, and they got a big judgment, it's always stand against standard and smart on the part of parties to even compromise. I'm talking about winning parties to compromise, because sometimes you actually want execution. And sometimes you may not get execution if you do not compromise, among other reasons, proper execution. So the compromise here obviously appears to inure to the benefits of Ghana. But it could have been worse than that. And I think moving forward, that's why I'm trying to be more interested in the preventive aspect.
Right.
Because if you look at the way, again, I think Kuku just indicated to us, the fact that there was a termination, and there does not appear to have been an immediate, stopgap measure to deal with the termination. And the fact that while there was...
Katie says that we were not interested in what was going on in court anymore. That's why we just didn't go. There was no point. We owed, and we felt it was important to pursue the out-of-court process rather than going to court.
Right, but that's exactly what shouldn't have been done, because it's very risky to do that.
Right.
Because if they hadn't compromised, they have a right to execute their full 40 million.
That's so.
And so if you don't go to court, the dangers of sometimes not going to court is that the other party has the liberty of getting the court to grant the relief fully. But if you do go to court, among others, you may plead things that will go to mitigation.
Right.
Look, I'm indebted to you, but I'm asking for a composition of the debt. A recomposition of the debt would allow you to pay according to a certain scheduled format. I'm asking that among other reasons, the other party should be, the interest should be calculated in a certain way as to bring down exactly how much I owe. The long and short is that if you're in court, you have the benefit and opportunity of getting the court to be reasonable with you. Because the thing about courts too is this: they understand the effectiveness of commercial transactions, and they do not necessarily want to kill parties or get one party to go under. And so once a party demonstrates sufficient willingness to actually, live up to its debt obligations, courts are always willing, very often, to give, the parties good terms to ensure that there's no loss on either side. But if you do not go to court, you expose yourself by getting the other party to fully get judgment, and in the process, the party may actually get a very difficult judgment against you. And once you have assets, they levy execution on these assets. And for a sovereign, defendant, like in the case of Ghana, you have assets everywhere. And so they may actually lay hands on some of these things. So I do not think that the issue of not being interested and therefore staying away is a smart legal decision. I think we should have been in court all along. Somebody should have represented us all along.
Okay.
And therefore, even the decision not to defend should have been brought to the attention of the court as a demonstration of our willingness to settle. That in itself would have made the court say, okay, go try settlement, come back and announce.
Okay. I want him... What I wanted him to do was to look at one small point,
sure.
And then I'll come to you. And it is also important to note that such default judgments are easily set aside, right? When you go back to the court.
Well, within our jurisdiction, yes. In Ghana, default judgment can be set aside. Not easily. You have to demonstrate, yes. You have to demonstrate something. But
okay. Now, we are talking about if you go to court and you put up a defense, or if a defense had been put up, it could have actually gone to sort of mitigate or brought down the amount of money, and you may find that maybe that is where Tsatsu is suggesting. And one of the defenses I seem to gather he's talking about was that the ship, the subject matter, Katie Hammond said, had been collateralized. Kandapa says it had been collateralized. They don't mention whatever figure, whatever was involved. Tsatsu comes to say it was mortgaged, and he doesn't mention any figure or anything to that effect. Well, I'm thinking really, and I asked that question soon after they finished. I asked that question, mortgage and collateralized, what are we talking about? Because frankly speaking, by the law that I understand, you cannot mortgage the movable property. You mortgage an immovable property. Is it possible to have gone to court to say, yes, this is a security we gave, and yet we think that the amount they are seeking on it should not be granted because it's absurd?
The amount that was mentioned would have been computed. Normally for, we call it liquidated claims. Normally for liquidated claims, you would have particularized the amount in your original claim itself, that this person owes you so much and this is how the debt came about. So the amount presumably would have been computed and therefore particularized. I'm not therefore sure what your question is in respect of whether or not the amount indicated ought to have been granted by the court on its own. I'm sure the court was convinced that the amount indicated was justified. But again, it goes to the question of the lack of defense. Because the issue about defense in court, the lack of defense in court, is that usually, especially if you come by way of motion, asking the court to grant you judgment in default, usually in the absence of a contrary affidavit, you'll be lucky to have a proactive judge who may ask you a few questions.
Right.
But very often the courts will just grant it without defense on the other side. Very often, once the technical issues are all in order and the court is convinced that the other party has noticed and is just not interested in the matter, you're taking default judgment, the court may grant it without further questions. And therefore, there may even be inaccuracies, as you just indicated, possibly in the figures. But the court may not have taken cognizance of that. But it goes to the question of you not being there to at least speak or bring to the attention of the court some fundamental issue.
Thank you very much. We'll take a very quick break here and I'll return to Kweku to deal with some more of the facts. Dr. Park has some very key important matters he wants to raise. Dominic is also itching to look at some other aspects of it. We'll be right back. This is Newsfile.
Ready?
You're welcome back. Thank you very much. This is Newsfile. And before we went on that break, I had just finished a point with Mr. Abochi. And I'm returning to you just a minute. And I needed for us to help in educating the people who have been watching and listening. And I was talking the last point about the debate about mortgage and collateral. Of course, our law says that the only thing that can be mortgaged, it says that is an immovable property. But we also know that you can mortgage a chattel. And so, like you say, when you mortgage, an asset, it becomes a collateral. What I'm interested in is, what are your rights after you have mortgaged the property?
Okay. If you want to use the term mortgage in the strict sense of Ghanaian law, a mortgage constitutes what is called a charge. Formally, when you mortgage a property, the property itself, you lose title in the property for the period of the mortgage. But now, the mortgage is merely a charge, and to use another legal word, it's an encumbrance. More or less, your right, the quantum of the owner's right is limited to the extent that he can deal in the property pending the full payment of the debt in respect of which the property is mortgaged.
But ownership remains with you.
The ownership still remains with the owner. So, there's no transfer of ownership. It's just a charge in the sense of it limits the total rights. So let's say your tradable rights. So you can't even dispose of the property. You can't, even under some circumstances, you can't even rent it. You can't use it in a certain manner which is inconsistent with the nature and character of the mortgage agreement. And so if we are using it in that context, then the mortgagee actually has rights of enforcement whenever there's a default in respect of
the mortgagee is the one who is giving you the money or loan,
exactly, the loan
for which he's taking a property.
Exactly. He has rights in respect to the property whenever there's a default as far as the loan is concerned. But it's not an automatic right for Ghana, for Ghanaian law. And I think it's important for me to stress this because this is not exactly a Ghanaian case.
Okay.
And so different countries have different laws. I'm not quite sure what the jurisdictional law of the place of enforcement we're talking about is.
Right. UK.
The UK is.
International agreements in Ghana is UK law.
Right. But in the case of Ghana, the law is that whenever there's a default, you have to go to court and secure a court order authorizing you to realize the mortgage. And even that, it is still the final option because there's always an attempt to get you to pay until there's failure to pay. I mean, you have no other means of paying. Then you realize the mortgage property by actually getting
so that will let you understand why in the first steps, the SG people were seeking to have the ship. They were seeking to have the ship.
Right.
And then they lost the first two attempts. That's what Tsatsu refers you to and talks about a successful defense in those matters. Now, Kweku, okay, I don't want to preempt you. I want you to look at the question of the debt having arisen. Tsatsu says that by the time he leaves, there's no judgment debt. You asked the question, but there was a debt. And so what?
Yes, Mr. Chikata said, well, at the time he was leaving, there was no judgment, and there was also no judgment death. Yeah, that was a non-issue, because nobody had made that an issue. There was no judgment, and there was no judgment death. True, but that was not an issue. He posed that question and proceeded to answer it, perhaps for whatever reasons, I can't tell. So I thought that was non-issue. But he made a statement to the effect that the SG made a claim of $40 million on GNPC in court. Also spoke about the fact that they took some credit lines from SG, which then resulted in the complications, and so they had gone into settlement with the SG coming with 20 million and the counter proposal from GNPC being 12 million. It's within this context that I thought was a singular omission on the part of the Commission, that it did not seek to interrogate if indeed that claim of 40 million made by SG was justified or not, and how it came about. How did they come by the figure? Because you had indicated that you've taken credits from them over a period. They had given you some monies, and on that basis they were making a claim. How much money did they give you? How much was the value of the credits that you took over a period of time? For me, was a significant omission, a question that was not asked, and I thought it was a singular omission, because it would give you a global picture as to what had happened. See, Mr. Chikata himself had admitted in a memo to the GNPC board dated 15 December 1998, and I'll read relevant portions. He said, with the continuing uncertainty over the actual start-up date for production, Societe Generale would not expand the credit line to address this price situation, pending the start-up of production. They required the positions to be closed, and this was done in July 1998. At the time of closure of the positions, the decline in overall value was at the level of $35.2 million. However, as GNPC had earlier received premium income of almost $5 million, the total amount due to Societe Generale came to $40.1 million. As at 15 December 1998, this is how much we owed Societe Generale. And you see, Mr. Kufuor was described as a debt collector for a foreign entity. I hold in my hands here, GNPC.
He said that he had almost become, it was sort of an attempt to,
Almost become, yes, an innuendo.
Okay.
It was an innuendo. And at that level, and who was saying it, and the platform gives it a certain significance and weight that we cannot underestimate. I wasn't surprised Mr. Kufuor's office issued a statement of some sort. But listen, this is GNPC board meetings. This is GNPC board meeting. Let me check the date. It's an extract from 16 December 1998 from the 100th meeting of the GNPC. And Mr. Chikata, paragraph 4.28, to a member's question on whether the $40 million debt was justifiable from the management's point of view, the chief executive said that the amount was justifiable as at the time of closure of the position. That is July 1998. This was at the time that the board, and I read from another page, page 5. Let me begin from here. Page 5. This was 25th November 1998 board meeting. Listen to paragraph 613. As to why the board had not been informed about this situation, that is the hedging situation and the indebtedness, the chief executive apologized for not informing the board earlier. Regarding the current situation, he stated that discussions were still going on with Societe Generale. He promised to present a full write-up to the board. Members expressed their concern and displeasure at this state of affairs, especially the fact that management did not seek approval from the board for the transaction. It was also felt that the letter signed by Societe Generale should have been addressed initially to the Minister of Mines and Energy. Of course, this is not relevant. I will make my submission. In his contribution, the chairman of the board, I'm sure we all know, is a very prominent economist, still in circulation, high-profile one. I will not mention the name now, but I think everybody knows. In his contribution, the chairman also stressed the need for the board to be made aware of any transaction to be undertaken by management, and cited the transaction with Societe Generale as an example of transactions that were not reported to the board. There are many more here. It is within this context. Mr. Chikata tells us that he prepared a brief for the Attorney General. Of course, unfortunately, he didn't have a copy because his computer had been stolen.
What he wasn't happy about was that the government appeared to have been fixated on Societe Generale's, position and not what he had presented to them.
You are reading my mind. That's why I'm proceeding. Unfortunately, the only exhibit he presented to the commission was his press conference statement of 6th September 2001. For me, it's significant. The only exhibit at this platform. And so many things he talked, the defense, the counterclaim, the Dr. Kolb's research statement, all these very, very material documents were absent. Bindman and partners, I think they've ceased functioning, so they don't have copies. And the only copy thing that he sent to the commission was the press conference statement of 6th September 2001. Fair deal. That press conference statement, it's here. I have a copy here. What were the particulars, the material particulars of the counter claim? You want an attorney general who is come to office to go and pursue litigation in court on the basis of a counter claim. The counter claim was this Dr. Kolb's research material. As he said here, I'm quoting from Mr. Chikata. An important element of the GMPC was the testimony of an expert on derivatives based in Chicago, Dr. Kolb, who wrote a report showing that Societe Generale had acted negligently in its advice to GMPC. This was it. Where is the copy of that research material? What was the nature of the negligent advice that they gave? I thought the commission could have asked these questions. Negligent advice, I'm told, you educated me here, that you can sue on that. So I'm not disputing the legal basis. But a commission that is interrogating the issue. Mr. Chikata, please, what were the elements that went into the negligent advice? The Attorney General you went to talk to, you gave him the elements. They take, and this board meeting has everything here. Mr. Chikata defended Societe Generale, defended them vigorously, and defended the transaction they had entered into. All here. Now, the Attorney General had a copy of this board meeting. He had all. You've come to him and you are asking him to engage in a protracted litigation based on a counterclaim that had no basis. Was it Societe Generale that advised GNPC that Ghana would produce oil in commercial quantities January 1998 at the Tano oil fields, which was the bedrock of the hedging transaction? The bedrock. When did we discover oil? What is more, to start production in commercial quantities? 2010 was when commercial production started. 2007 was when we discovered. You expected the Attorney General to pursue litigation in court for the sake of it, because you had a counterclaim based on a research done by Dr. Kolb. Meanwhile, it is within the exclusive jurisdiction and domain of the GMPC to determine when we will discover oil, not Societe Generale. So, if it was not, Societe Generale did not determine the start-up production date, fair deal. What is it that they told us to do? You said they train our personnel, even the market and research department. He said so, and it's also here. And he was asked if even that didn't amount to conflict of interest. But that was one of the things we were going to use as part of the negligent advice, that they ended up even training our personnel.
If you
Attorney General obviously took a decision that this case cannot be pursued in court and that it will be pursued outside. I'm not a lawyer, and I think because we have brilliant lawyers here, and indeed, he's one of the people I listen to when it comes to law. So I will read this, and then you can interrogate it.
Which one is this?
This default judgment, which I remember I published, and it became an issue here, that because there is a signature of Norton Rose down.
That's the entry of the judgment.
Fantastic. And indeed, I recently saw another copy, Ghanaian example, when Justice Apau gave judgment debt of 16 billion cedis old against GMPC the day before this judgment was passed. It had been entered by a Ghanaian legal firm.
Kuku, it is the practice. When you
you
brought it up the last time, I told you
but
it's
you were
the practice.
Here. I was told that it's fake. And it was fake because of this. I was told so. And I've been bastardized all over.
It's a misunderstanding.
But, thank you. But this is what it says. The covering letter from Norton Rose was to the bindman and partners. And it says, Societe Generale versus GMPC. We are, of course, aware, for the attention of Judy Kemesh, we are, of course, aware that you are no longer on record for GMPC. But enclosed for your information and attention, a copy of today's judgment made pursuant to the order of Mr. Justice Thomas made yesterday, yours faithfully, signed by Norton Rose. Now, this is where I think I want dedication. Judgment, they've titled, dated this 6th day of June 2001. Upon the defendant having failed to comply with the order, a certain order had been given, of Mr. Justice Thomas, dated 5th June 2001, and the defendant's amended points of defense and counterclaim having been struck out pursuant to the said order, and upon the claimant having abandoned his claims under paragraphs 3, 4, and 6 of the prior to the amended points of claim, it is this day adjudged that the defendant do pay the sum of $40.8 million, or such sterling equivalent as at the time of payment, together with the interest to be assessed and cost to be the subject of a detailed assessment. This, the first paragraph about the defendant having failed, and the second one about the claimant having abandoned his claims under certain paragraphs, gives me the impression that a certain understanding had been reached. I'm not a lawyer, but this is the impression I get.
Okay.
Now, bottom line, it was not the default judgment that was operationalized or executed. The 19.5 million arose out of a settlement negotiation. I'm not a lawyer. I don't know whether there's an extension between the two. So as far as I'm concerned, the point that the AG did not put in a representation, and so that was so fatal to our case that we ended up with paying, first of all, having a judgment, default judgment of 40 million, and paid 19.5, shows that something was amiss on the part of the AG. And you know what is done?
In fact, when you look at the entry of judgment, the plus interest would have gone far above the 40.
It became 47.
47.
Yeah.
47. Now, Tsatsu's defense, which he said at that place, and that's significant, about the $12 million. My brother, why would an attorney general...
If you can finish on that quickly
let me
me.
finish.
Yeah.
Why would an attorney general pursue this course of action? Listen carefully. He talked about discussions that they were having with Societe Generale, both before their court actions and after. Then he gives his suggestion here. Societe Generale settlement proposal was for $20 million. This led to a counter proposal from GMPC lawyers for a $12 million settlement, payable in installments from the expected commencement date of production from the Tano oil fields. Societe Generale lawyers asked for certain clarifications on this proposal, and this is where things stood. Listen, the $12 million counter proposal was first to be paid in installments. 2, it was linked to expected commencement date of oil in Tano fields. And again, I ask, when did we discover oil in Ghana? And where? Tano oil fields?
No.
So who provided the kind of advice that went into this transaction?
Okay, thank you, Kweku.
Something, just a second. I think just to, what Kweku read, vindicates the premise on which I laid the statement I made earlier, that not all the facts appear to be known. And I think what he just read appears to vindicate that fact, that the lawyers might have agreed. And you see, these things happen, but maybe for documentation purposes. The lawyers might have agreed that we have certain claims we are going to abandon. We are not going to insist on that. And we're going to ask the court to strike out those parts.
That's right.
On the other side, your counterclaim, etc., you're also not going to go to court and push these things. And then in furtherance of that, we're going to negotiate.
That's right.
These might have been discussed on the sides, and we may not know. But and that's why I earlier said that it's not standard practice to just stay away. But who knows? They might have said things which were not documented. And I think the statement you read is probably
Can I fit in this for the final one? The mortgage matter, again, so that we can get a legal understanding, or education rather. This is a letter dated 14th January 1998 from SG to Mr. Chikata. For the attention of Mr. Chikata, I said, "Dear Sir, the title is The Fuel Hedging Contract, ISDA Master Agreement, dated 3rd February 1997, and the Associated Margin Agreement, dated 3rd February 1997, agreed between GMPC and SG. Excuse me. We have requested that the GNPC provides SG with additional security with respect to the above two facilities between ourselves. You have agreed to provide with all possible haste such additional security in the form of a second mortgage on the Drillship Discoverer 511 and a first mortgage on the semi-submersible drill rig Asteria. The intention of both parties is that the two security agreements be executed as soon as possible. I will be grateful if you will execute the attached copy of this letter in acceptance of its provisions, in confirmation of your agreement thereto, and return one executed copy to Societe Generale. Yours faithfully, William Nagley, Director, Head of Commodities and Trade Finance. Under it is, I acknowledge and agree the terms of this letter. Signed, Tsatsu Chikata. Date 14 January 1998. I don't know what this means in terms of mortgage documentation.
Right. There are many people who are watching and listening, and they have also been joining the discussion. I have Mickey Mann, and he says that why did government at the time dissolve the board of GNPC? Why did the Attorney General at the time sideline the lawyers of GNPC on the sale of our drill ship? Who had knowledge of the value of the drill ship? I smell corruption and chop in there, but hard to say at which level. Atta Moro, right from Wellency, Tsatsu and the NDC are trying so hard to equate the sale of the drill ship to the Wyoming judgment debt so as to score political points. They are bound to fail because the two are not identical. Initially, they claimed that they did not have documents, and when they were shown the documents, they are not now talking about legal procedure. Bediako writes from Kumasi, says, because of APAC's introduction, it's fair to state that record has been made of the amount of time used, the amount of documents retrieved, the type of questions asked, and the number of people called, and yet to be called on the $24 million worth drill ship, and these would be juxtaposed with other high-level, high-valued judgment debts to test the true motives behind the work of the sole commissioner. His credibility would be judged by his results. Thank you very much. Now, Dr. Park.
Yes.
First of all, there was a critical point you have wanted to make. Just go ahead and make that, and let's hear you on this back and forth about the prudence in the decision of the Attorney General and where we have gotten to. And what's your expectation in the end, really?
Well, first of all, I think it is very important to state that Tsatsu, like the other two gentlemen who appeared before the commissioner, stated his side of the case. And I have no reason to doubt the veracity and authenticity and indeed truthfulness of what he stated. And I think that in many ways my line of thinking is in synergy with what lawyer Abochi has stated, there are still some fundamental questions that need to be answered. Quite clearly, the justification and the motivation behind the withdrawal of the litigation, which I think and many Ghanaians truly believe would have strengthened the hand of the state.
You would want to be using non-pursuit rather than withdrawal.
Well, yes. I mean, thanks for the correction. I think this is a point that still has to be pursued because we need to understand what went into those decisions.
Kweku has given you some of the reasons.
Well, that is Kweku's version.
Says the counterclaim was not a strong one.
That is Kweku's version. I mean, with all due respect, until I hear the final pronouncement on this matter by the sole commissioner, I am not convinced.
It doesn't matter that he shown you Chachichi Kate's press conference, in which he refers to what should be the bullets.
But I am not going to give senior comrades' statements any much weight above and beyond what Tsatsu himself has said. And so I am waiting for the final decision to be made. But I think that it still remains an issue that, you would have an option to settle for less, and then you go for an option that allows you to settle for more. And I think this is the crux of the matter. And until all the interested parties have an equal opportunity to present their case, and until we perhaps verify other documents which I don't think are still within the public domain, we can never have closure on this issue. But I wanted to make...
The 12 million.
Well, I just wanted to make
installment and linked to commencement date foiling the future.
With all due respect, I mean,
even SG would not have accepted that. How to pay them in installments
and
link
it to oil? There is no guarantee that our continual pursual of this case, at least the legal angle, could not have strengthened our hand in terms of even a negotiated settlement. That is the point I am trying to make, and what justified that. And it is not entirely conclusive that there isn't going to be any more information or evidence to come up from Tsatsu other than what was presented to the sole commission.
He didn't tell the commission he had some coming. He didn't.
Yes, he didn't, but that doesn't mean that such information. Press conference that doesn't mean that information may not still come to bear. I don't know why you are so cynical and extremely
press conference
defensive.
The only
but let me make this one general point, and I wanted to touch base on what Honorable said, which I thought was very significant. You see, there is this tendency for us to always look at situations vis-a-vis the type of political advantages that we are going to get. And it is not right, it is not fair, it is not helpful to our nation. Today, Honorable is suggesting that out of expediency, based on the need to, deal with it expeditiously and to save time, it was only appropriate for the then Attorney General to do what he did. And yet, I was taking notes.
To save time? Yes, you didn't talk about time, you
said that.
Interest.
That is exactly that. But that is to save us any further accumulation of interest which is supposed to benefit the state. Yeah. And yet you have a problem with similar settlements made by others who are not in your political party.
Specifics.
Wow.
Well, yeah. Well, we all know about the CP case and others where similar arrangements were entered into to allow for the state to pay less in terms of the debt that we owe. And yet you and your group in Parliament, you have made an issue of that. So I just wanted to put this in perspective.
This example.
No, it is. You know about the CP case and others, right?
The tax revenue that we allow them to go.
I'll do it.
So you see that your interpretation of that is different from this. Okay. But the point I'm making is that is exactly the case that lawyer Abochi was making. That it is about time that we begin to look at these issues from the global perspective and also help to identify where we are falling short. Because we cannot continue this way. When it suits us, we play the ostrich. And when it doesn't, we are on our soapboxes screaming as loud as we can. And I think one of the purposes for the setting up of this judgment debt commission, as you indicated earlier on, is to also allow us to see the institutional failures in terms of what we could have done right, what we need to be doing now, and even, if possible, to retrieve some of these resources that we may have lost to the state. Because you asked the question about what is going to come out of this process. So that is what I expect we will be able to...
There are those who also expect that there will be some prosecutions.
Rightly so. If there is reason for us to pursue
going by
people...
the evidence that has come out so far,
it will be
do
waste of
you
time.
still suspect that that will happen?
Well, I am not going to preempt what
let me make my point. Chasing Imira,
Sorry, I'll come to you briefly.
No, it's okay. The point I am making is this. I don't want to preempt the outcome of the work of the commissioner. But there is no reason, if you look at the Constitution and the powers that can be granted to an inquiry like this, it is quite possible, if there is clear evidence to suggest that there was some connivance or collusion or willful action that has caused the state to lose resources, there's no reason why, the needed processes cannot be commenced to sanction those who may be deemed responsible. So everything is on the table as far as I can tell.
Thank you very much, Clement Apak. Now, Dominic, there are those who are saying that Nana ought to appear. You are also saying that, well, you don't think it's necessary, but even if he's called upon, he will appear. Have you spoken to him to gather from him that he is willing and he's interested in appearing before the commission because something has been said about him that he feels that he ought to defend himself?
No, I have not spoken to him personally. I've spoken to him on other matters recently, but not on this particular matter. I know Nana Akufo-Addo very, very well. And I know the passion he has for this nation, what he can do and what he cannot do. And I know he will not run away from responsibility if one were to appear along the line. But you see, Samson, let's be very clear. What is the use inviting Nana Akufo-Addo? What is it that we are looking for now? First, there was no debt. It's clear that Tsatsu Chikada has a lot of questions or a lot of answers to give the state of Ghana. First, you get involved in a transaction that the board is not aware of. The board chairman is then blaming the management to say, well, when you get involved in this type of transactions, at least you should let the board know from the board minutes that we have been privy from Coco Bako. It leads Ghana to a debt of 40 million that you, in the board meeting, stated that, well, SG are entitled to. I think the Judgment Debt Commissioner did not do all of us a lot of good by not interrogating Tsatsu on that particular aspect. That along the line, there were board meetings. Where are the minutes? 2, in that memo that Tsatsu wrote, he also agreed that, well, SG were really owed 40 million. So the subject of whether we're owing them or not is clearly settled by Tsatsu himself. I thought the Judgment Debt Commission needed, seriously, to interrogate Tsatsu on that as well. 3, there were other documents that were being sent to court for counterclaims. Where are those documents? Why is it that Tsatsu did not tender those documents? Where are they? Tsatsu should have those documents. Tsatsu should be called to come back and tender those documents. That's the third point. But for me, I'm very clear in my mind, and the people of Ghana are very clear in their minds.
If Tsatsu feels that there's enough documentation that's been presented, he doesn't have to submit any further.
But he is just here saying that people are doubting the authenticity of these documents. And so Tsatsu needed to present documents. But it's very clear in my mind.
Tsatsu has not gotten the opportunity to say he doubts the authenticity of the document, or he had the opportunity and didn't doubt the authenticity of the document. So let's not take it at him. If you want, address Clement Apak.
No, that's okay. But I'm just saying that in my mind and in many people's minds, it's very clear that from Tsatsu, who is the principal witness, if there was going to be a court case anyway, if we wanted to do litigation, Tsatsu was the principal witness. Because the board was not privy to that decision he took. He was a management, and they took that decision. He and the management took that decision. They were aware, and they had agreed. And they were arguing and convincing the board that SG was owed 40 million. So it was very settled. If it was settled that we're owing them, Tsatsu's 12 million offer that was linked to commercial production of oil was going to rather cost Ghana even more. And no bank, and let me be frank with you, no bank will accept those kind of terms at all. In fact, if the interest had accrued by 7 million at that time, if we were to wait to the production of oil, not even at the tunnel, but at the deep sea, by this time, interest alone would have been hitting another 20 million. And I don't think that is good for us. Let me be very frank, that the government at that time took a decision that any government that loves Ghana will take.
You made that point.
2, I'm also telling you that it was not the non-representation of the attorneys general or the government at the court that made us pay the 90 million. It was very clear that we owed SG, or SG had 14 million to pick from us. The government at that time thought that the best thing was to negotiate with them. They did. They reduced it to 19.5. We have 3 million outstanding. It has been clearly shown where that 3 million is. And I don't think that we should worry ourselves calling Nana Akufo-Addo to come and answer what? Is it about the 19.5?
As far as you're concerned, whatever this commission is looking for is gotten already.
I think there's enough
it's
evidence.
End of game for it,
I think
as far as this issue is concerned.
Unless maybe somebody is stretching some political angle to it, there's enough evidence already on the table to show clearly that there is no need to worry other people about it. The only people who need to worry is why did Tsatsu not consult the board in taking that decision that led to the loss of 40 million? That's the question we should be asking.
Now interesting. I'm coming to Abochi right away, and I want Abochi to address this other one. That's been around. I'm coming. I just want to prompt him about it. That there are those who say that, look, K.T. Hammond's testimony, before the Judgment Death Commission contradicts what he's been saying on radio. I want to ask you, how fatal is that to the entire process? For example, he has said on radio that he personally took the check and came down and handed over the check, and then we get to the commission, and now he says that, look, this was handed to Chris Podo and that aspect. And people are saying that must also be questioned. I'll come to you briefly on that. But
I wanted to raise a point that I would hope that Lawyer Abochi will give clarification. The letter that Senior Comrade Kwekubaku read quite clearly indicates that the agreement had a futuristic component to it. If that was the case, wouldn't that have made it possible for us to challenge the fact that they were coming after our drill ship because we had not discovered oil where the agreement was suggesting that we would have discovered, and that would have been the basis for them to come after us?
That's a good question.
But let me
in
the agreement. Then what is the basis for them to come after us?
But Samson, I also want the lawyer to help us.
First of all, and all of you are not paying for that consultation.
But first of all,
that is why he's here.
Access Legal should issue the.
No, but first of all, K.T. Hammond may have said a few things outside the commissioner's jurisdiction. When he went to the commissioner, he swore an oath.
No,
that
I'm asking him to address that question.
No, but that's what I'm just asking.
You seem to be answering.
I'm not answering. I'm giving you an angle to it so that he will answer. He swore an oath. I'll speak the truth, nothing else but the truth, whether by the Bible or by the Quran. And he swore by the Quran that he will speak the truth. Is it not the evidence that is presented that people are going to deal with? Because he's not been cross-examined by other evidence people have brought. Or you think that hearsay, as I would say,
I just told you that you are attempting to answer my question.
I'm not attempting.
No. Hold on. Now let me just do this. You have to keep your conversations going with MTN into SOAR. Now, each time you top up with any MTN recharge voucher, you get free minutes to enjoy longer conversations. No subscriptions required, no long things. Just top up today and enjoy your free minutes on MTN. Go on with MTN into SWOR. Your bonus minutes can be used for MTN to MTN calls only. So go on, keep the conversations going. Welcome to the new world. MTN everywhere you go. And as I told you earlier, once again, I remind you that Star Assurance has superior insurance packages for you. And it is important that you acknowledge that having won the CIMG Insurance Company of the year 2012, and they enjoyed a very illustrious position on the Club 100 rankings, they are even ready to give you more. all they want you to do is call them. The line is 0302 240 632, or you can visit their website, starassurance.com. And I remind you again that go to Errata Motors. They are right at East Legon, Lagos Avenue, opposite Body Talk, near GT Bank. And you can call them on 0244 445 268. They will give you the best deals in vehicles, Mercedes-Benz, Toyota, whatever it is that you want in a vehicle. Just get to them and you get the very best. Vital mineral water is full of essential minerals that revitalizes your body. Its mineral content is not artificially infused but tapped from a depth of 200 feet and bottled at source using a world-class technology that employs a fully backward integrated system. Makes Vital mineral water one of a kind. Vital mineral water is packaged and bottled absolutely with no human intervention, meaning risk of cross-contamination is reduced to zero. So that is important. Get Vital mineral water and get truly revitalized. Abdul Malik, can you do that in 30 seconds?
Wow.
Yes, because I'm going to.
I told you he was going to deal with the Nana thing. Since it's going different way, then I might as well finish the Nana thing so that we can move on a certain trend. Okay. Otherwise, after he's
done, you don't think it is necessary for Nana to appear?
No, I think so. I disagree with Nito. Yes. You see, one, questions have been raised.
And I want you to be very brief for that.
Questions have been raised as to the legal issues relative to, one, the power of attorney, how it was done, procured, and all the rest. They've also raised the question of there's a brief that Tsatsu said he gave to him. We don't have a copy. Nana must respond to that, and perhaps if he has a copy, he can make it possible. PNDC Law 64 has been brought up to the fore in relative to if the board doesn't exist, what happens?
Yes.
Or why should the board not exist at all? I mean, these are issues. You realize that Kandapaa consciously and I think deliberately avoided dealing with those issues.
And then K.T. Hammond attempted to deal with
because he's a lawyer. He's a lawyer, so I wasn't surprised at all that K.T. made. And there was a challenge. The two of them contested. On a certain point, K.T. had to bring in some authorities. So to that extent, because of the legal questions that have been raised, I think the former Attorney General, who played a prominent role in all these things, could come up, appear, that would be okay. We lose nothing. I think we will gain. That's my view.
Thank you very much. Can we do a little exercise, please? How many months has the sole commissioner been sitting so far, and how long has he got to go? How many cases has he looked into? How much of his hearings have been devoted to this $3.5 million Drillship check? Can we, not 22 months, please, can we seriously not trace this cash with all the pigeonhole sourced documents and all? And what can we make of the real motive of the sole commission after K.T. Kandapaa's show? It makes for good entertainment, though whilst typical of Ghana, the real issues facing the suffering masses are ignored. Okay, and this is actually coming from Gabi Asare, co-publisher of The Statesman, who is currently making use of his passport away from the heat of the kitchen.
he took advice of
now, can we address the few issues that we have brought up?
Right, I think there are two questions you asked. The first one is what Mr. K.T. Hammond says
on radio and what he went to say at the commission.
Now, first of all, we need to remember that the commissions of inquiry operate as quasi-courts or quasi-adjudicatory bodies. In that respect, courts do not have knowledge or do not take cognizance of things that are said outside of the courtroom. So whatever he says on radio, etc., they are not matters of record before the body. Now, a commission of inquiry is a body of record, so they deal with records. The difference, though, is this. A court would not be interested in doing an independent investigation, but a commission can go after this for itself. But if the commission goes after this for itself, the question would also be, what will be the probative value in this being used as a means of actually getting him to contradict himself. Now, first of all, if I'm coming before the commission, I may be well prepared. If I pick up a phone and speak to a radio station or show up at a studio, I may be responding to something out of emotions. The possibility of me contradicting myself exists without that actually turning out to a conclusive statement that I'm actually lying. In other words, if I'm coming before a commission, I'm prepared because I know I'm going to give a testimony and the oath in respect of which I'm bound. But if I speak to a radio station, I may not be prepared, I may be responding emotively, and therefore I may end up saying things.
In short, you're saying this is not fatal to his testimony as regards the credibility of his testimony or himself?
No, it is not fatal at all. It is not fatal. And, when I started speaking, I'm still very much a bit uncomfortable, and I know that Newsfile is notorious for this. We speak personality a lot. But I'm very, very concerned because these issues implicate big systemic issues.
Yeah.
There are things I wanted to say at the beginning I couldn't. But for instance, what is the policy, let's say, on the sale of state assets, for example? Even though this was not direct sale, it was pursuant to a court order, among others. But there are accountability issues involved. I think Kuku has a lot of...
And strictly speaking, it was not a sale pursuant to a court order.
It was, there was a court order. Let's say execution.
Yes.
There was an execution levied against it. So
of a certain amount.
Right.
And the state decides that this is how we want to pay it. We want to sell a drillship and pay.
And
it's still pursuant.
The registered mortgagees had applied to a commercial court in Oman and had it seized. We had ownership, as Mr. Abuchi said, but we had lost possession and control.
Okay.
At that point. So thank you for that. So I think, among others, the issue of accounting and accountability, the process, I think things appear to be a bit messed up. Issues of reporting, I'm not sure if this was captured in any of the budgets to even indicate, for instance, there's a major state asset that is gone, among others. So I think, and it's important that we try taking out the names and the people involved, the actors, among others. It is a major systemic issue, and let's not forget, this happened in the heat of a transition. That had happened not long ago. The question of institutional memory, if frankly many of these things were documented and again, as Kuku indicated or as some of the panelists indicated, how the matter even arose in the first place, who did the initial negotiations that resulted in this litigation, that resulted in this massive, if you like, loss to the state, among others. So if we look at this from a broader perspective, for me the issue of even mentioning names and dealing with who was involved at which time, of course, these are also important because the law on cause of financial loss to the state is still around.
Right.
So, no doubt, there are issues of personal responsibility if we can establish that. But I think moving beyond that...
Is the Attorney General liable for his professional advice?
The Attorney General could be liable if you can demonstrate that he has actually acted in a willful manner that has resulted in causing financial loss. The thing about that law is that it doesn't deal with the issue of dishonesty, but it deals with the issue of willfulness. And willfulness means you could have done something you didn't do, among others. But again, let's not tie this into part of the discussion was whether we should have even defended it in court, etc. Part of the business of the Attorney General is to also decide which matter to litigate.
Right.
Because, mind you, it's a very busy office. And there are some things that you can choose not to litigate, and you might actually save yourself some money. It is possible that a judgment was done properly, and I think, as Rico was saying, probably if he speaks, maybe some of these issues will be clarified. I am quite convinced, again, hearing all the things I've heard, especially with the last document you read from the order of the courts.
Yeah.
That document, I think, speaks volumes, and we probably need to find out a little bit more in terms of the court records. What we have is a very terse court order.
Sure.
But beyond the court order, there's a court record.
Sure.
And the court record indicates exactly what has happened, which led to that order. If we can lay hands on that, and we can find that out.
We're interested in finding out which claims they abandoned.
Well, correct. We don't know all these things. Yeah. We don't know what the claims were, which they abandoned. We don't know what our counterclaim was, which was struck out. We don't even know whether our counterclaim was advanced and was struck out, or it wasn't advanced at all. That was just on paper.
All the amendments that are being talked about.
As a lawyer, I'm quite restrained to make conclusive statements because there are so many things which are still unclear as far as those documents are concerned. And it seems to me that people who took certain decisions might have taken those decisions with the benefit of information I don't have.
Don't you think the commission has the capacity to have these documents?
Absolutely. No, they will. If the commission writes, if we write officially, and this is supposed to be a court in the UK.
Yeah.
If we write officially, serve this through the Ghana High Commissioner's office in the UK, and it's served on the UK High Court Registry, they will supply us.
We know about.
We'll get the full detail of information.
We know about jurisdictions where they wait for a certain period of time and then they destroy documents.
No.
That may not apply to
No. This matter has happened. It's less than 50 years old. If you go to the UK, they have records that go way beyond 100 years. You will get this. If you go in there, we'll get the full record of what happened in court for the entire time, which represents the judge's notes. And the judge's notes captures the detail of what happened one stage to the other, which may explain in many ways exactly what happened and therefore may vindicate some people.
They will soon be made available.
All divestiture receipts are captured in the budget.
Those documents will come. Those records will come.
We don't capture individual sales. All divestiture.
But I think he was asking a question on contingency, that they said we'll mine oil.
Yeah.
Was it based on the fact that payment will be made when oil shows up, among others? I haven't seen the contract.
Well, I was saying
start
that
of commercial production of oil at the Tama fields.
Right, and there was never a start of production, commercial production.
Exactly.
As you said. So clearly the contingency in that contract never arose, which would have activated some enforcement in terms of the rights and liabilities therein. Again, these are major things that we have to look at. Probably we may have been distorted by the issue of where's the check, who was it paid to?
Yeah, I agree.
And probably there are some other surrounding issues which we may have to deal with, which may actually go to the root of whether or not we may not have even paid somebody for free. And again, and that means that the SGS is just SGS, right? SGS itself may have questions to answer. The question of the negotiation that led to those rights and whether or not at the time they even enforced those rights, when the matter was in court, whether or not we were even supposed, whether or not we were even liable in the first place. So many of these things, I am a bit constrained to speak.
The chief executive was defending them.
Well, that's the point. That's what I'm saying. So
he was defending.
There are just so many things.
He wasn't
the chief witness for Ghana.
He wasn't collecting debt. He was defending the debt.
All right, gentlemen.
He was defending the debt.
Yes.
So he has even agreed to it.
But that was a bad statement.
There are just so many things we are not clear.
Gentlemen, okay, so
very bad statement.
He was
and I think the
almost
commissioner
a
should have
debt
allowed that
defender.
statement to be made.
Gentlemen, let's move on at this point. And we have Tom in Cantonment, and he writes, he says that Tsatsu's advice to pursue the case in court is seriously misplaced since he got the GMPC into this debt in the first place. What makes us think that his advice would have saved us? Kofi also says that I would like to know if that discoverer was the only drill ship Ghana had at that time. If no, what has happened to the others? They have not come up. If they do, I'm sure that they will also be taken care of. Abdul Rashid says, please, Ghana is bigger than any political party. You're right. Let's allow the sole commissioner to carry out his assigned duties. And Kofi, right from what? Kofi Asafo, is it Kofi who is writing from Asafo? He says, thanks for the education on the legal implications of charging a property as security for the payment of debt and interest. If anyone is to be arrested, it should be the people who created the encumbrance on the property in the first place. Samuel Frimpong. Kweku is a very great journalist. If a whole GMPC has no document concerning this ship saga, and Kweku is able to provide these documents from start to finish, I think Kweku should be recognized for a good job done. Thank you very much. Okay, we'll take a quick break here and return to look at the fortification of the Fortis merchant problem. Thank you very much. You're welcome back. This is Newsfile on Joy 99.7 FM on radio, on Joy News Channel, on Multi TV, and over a dozen affiliate stations across the country. My guests, Kweku Bako Jr., Clement Park, Dominic Nitiwul, and Kofi Abochi. It's difficult to cut away the earnest that I have known him, but he likes to be referred simply to as Kofi Abochi. Now, have you ever imagined sounding different over the phone whenever you make calls. Share some fun with MTN Magic Voice, another exciting service only from MTN. With Magic Voice, you can choose to speak to your friends and family from among 3 funny voices. An animated cartoon's voice, the Husky King's voice, or a shrill female voice. To make a Magic voice call, prefix the recipient's number with 518, that's all, and just send 518 and just send, and voila, you will enjoy it. You just love it. If you don't like it and you want to stop, same number, send to unsubscribe. Remember, with Magic Voice, it is not what you say, but how you say it. Welcome to the new world. And let me tell you this too, Syndicated Capital, in collaboration with Multi TV, will be launching its new service center in Tamale on December the 4th. To commemorate this event, there will be a float on the principal streets of Tamale, football gala for the youth living in the southern, northern, eastern and western parts of Tamale. Prizes will include LCD TVs, fridges, rechargeable fans, wax springs, multi-TV digiboxes, and many more. So December 6th, 2013, there will be a community clinic exercise where multi-TV installers would visit home to provide free after-sales support and instant installation on all sales. Multi-TV, just thrills. So for further information, you can call 024-331-9456 or 0501-295558 for registration and for more information. So note that date, the 4th of December and the 6th of December. Interesting in the Tamale metropolis. So get ready and be part of the interesting stuff that is going on. Now, 40s, and you know that the Bank of Ghana has come forward to say that it appears that we are all talking about things we don't know about. And Andy Awuni and his organization have gone to court, and presently they are seeking an injunction against the sale. Well, Dr. Wampa appears to say that we are talking too much. We don't know what is going on, and he's giving us information. And he says that the deal was above board. All the processes that were required to be gone through were gone through, and so whatever anybody is saying is not correct. And also it is important that he says that for those of us who have been talking about the fact that Fortis is only bringing in 90 million Ghana cedis, we should also note that they are expected to invest another 50 million Ghana cedis in the next 6 months. So put that together and you have 140 million and not 90 million. And don't compare that to the Rand, South Africa Rand Bank's offer, which was rejected in the region of 170 plus.
199 actually.
199?
Yeah.
Okay. I start with you, the minority in Parliament, who first of all declared this, and what I said last week, you were unequivocal, you were very categorical that this was a scam, was a sham, that this was fraud. He's telling you that you don't know what is going on. They passed the processes which also passed the test.
No, first of all, he is the one who is not helping the people of Ghana, because he's the regulator, and whatever actions that the Bank of Ghana will take should be in the interest of the people of Ghana. You have a bank that the government through the board has decided that, well, because of the bad debts, because of the underperformance, let's do away with it, let's sell it, let's diversify it, and revitalize the bank so that at least it can help the people of Ghana. A bank comes in from South Africa that has a capital base of about $109 billion US, is the second biggest bank in Africa, and for some reason, the Bank of Ghana on the 12th of July 2013 releases a press conference and says, well, we are putting a plug or a stop on the transaction because of certain things that we asked them to do and they couldn't, so they couldn't fulfill the agreement. you remember that if it's in terms of pumping in capital, it's obviously one of the best that we could get at that time. But what was their offer? 91 million for 75% shares. That was what they offered. That $91 million, we were going to at least buy 75% shares, meaning that SNIT, which you and me, all of us, our money is there, still had 23% shares, and then SIC had 2% shares in that. That was abrogated. It's history. We don't want to go about that. Then comes Fortis. That was registered somewhere in June, just around the time that the people of Ghana were talking about the fact that we didn't want that Fortis Bank, we should be careful selling our assets, we should do due diligence. Then comes Fortis. That was registered. Of course, it's wholly Ghanaian owned. We know who the owners are. It was registered with a share capital of about $5 million. Of course, I can go and register a bank and say, a company and say, I have $2 million. I may not physically have that $2 million, of course, but because of the structure of our registration at the Registrar General, I could say I have $2 million of it. I may not even have even $1 million, but it happens. But they have been given the license, or they have been given the go-ahead to go ahead. What are their terms? They are taking on board 90% shares, not 75. They are also giving us 90 million Ghana cedi. That is about $44 million, not the $91 million. Remember, the South Africans offered $91 million for 75% shares. Fortis is offering $44 million for 90% shares with an investment of about another $30 million or less in the next 6 months. Of course, the South Africans were going to invest more than that anyway, because the agreement was that they should revitalize the bank. They were going to invest 3-4 times that. Then we believe that this is the best deal for us. Now, the biggest problem why they're selling the bank is because they're
as far as you're concerned, more importantly, it's about the amounts involved compared Fortis with...
that's just one aspect of it.
First round.
Yeah, that's just one aspect of it. The second aspect is the real reason why the bank is not performing is because of its debts. That's basically the real reason. It's because of its debts. It's not able to collect their debts. Remember that most of the people were servicing their debt until the NDC came to power. Remember that. They were servicing their debt. I'll give you one example. EMP, engineers and planners, for example, were servicing all their debts until the NDC came to power, and their debts, they stopped servicing their debt from 2009. And also remember that when this matter came, engineers and planners, for example, because people were saying that it is not good for the president that your brother's company is the largest, that's what people were saying, that is the largest debtor to the bank, and they are going to more or less forgive you the debt, because by the current arrangement with Fortis, they can only recover 30% of the debts of the bank. So for everybody who owes, well, you may be expected to pay 30% to the bank. I hear the bank, the engineers and planners have said they will pay their... We've heard that before. I mean, last year when this matter came up, we heard it before, that they will pay. Suddenly they have not paid.
They didn't give a definite date. They had actually spoken about arrangements
to pay.
But
they have not. Now another company is coming and says that, well, we can only be able to recover 20%, 30%, 70% will not be recovered. I think it's a bad deal, in all honesty. First, the Bank of Ghana has failed to give us where the owners, Fortis, are their source of income. They have failed to tell us the real due diligence, how much they have, what they are putting in. Just another 40 million Ghana cedi that they are thinking of putting in. I mean, that's woefully inadequate. If the debtors, that is the debtors to the bank, can just pay even 50% of what they owe the bank, I don't think that the bank should be sold. Because if you are just looking for another 140 million, and then the huge debtors alone, just two debtors alone owe close to that amount, then we should rather be looking for our money and not sell that bank. 2 people from the board have resigned because they thought that it was a bad deal. They thought that the way things were going, they were no good. Secondly, why would you exchange 199 million for 90 million. Why will you exchange that? And the governor of the Bank of Ghana is telling us we don't know what we are talking about. Why will we exchange 90% shares for 75% shares? Somebody is buying you your 75% shares for 199 million Ghana cedi, with a promise that because they're a huge bank, they would infuse a lot of money into the system. Somebody then comes to say, well, I'm going to buy 90% shares for 90 million, and you think that is the best deal because they are Ghanaians? Of course, I would wish that Ghanaians take over. I would wish that Ghanaians are able to become people and manage big companies. But this is naked robbery of the first order. And I said it, it's not good for the president. If I were him, I'll put a plug instantly. Because we know that the lawyer for the president is the same lawyer for the largest debtor. And he's negotiating both. It's wrong. Okay. Morally, it's not good.
You think it's proper?
It's not good.
This inference you are making, do you think it's proper? Do you think it is really fair?
That what?
That because the lawyer for the president is acting for this company, which is a legal entity, I mean, there's some immoral thing going on.
No, you are not getting me. I'm not even talking about the president himself. I said the lawyer for EMP is the same lawyer for the same the company. That's the largest debtor. Is the same lawyer that is for the Fortis, the one seeking to buy.
Right.
And I think that it is not good. It's not good for us. In fact, for conflict of interest, you should have stepped out in this particular deal. The largest debtor is represented by a certain lawyer. You owe the bank. If the bank were, for example, if the 58 million had been paid by engineers and planners, owned by the president's brother, the bank would not be seeking to be diversified. They will not be looking for money to be sold.
Interesting.
Secondly, the same lawyer then represents not just the president, but he also represents the people who are coming to buy off that asset. It's so murky, it's not good for us. And you would tell me that any business will forgo 199 million for 75% shares and rather be clinging on to 90 million for 90% shares. We don't get it.
90 million Ghana cedis, not dollars.
Yes, I'm talking of 90 million Ghana cedis for 90% shares. We don't get it. You see, we are behaving like
beyond the talk by the minority. You are deputy minority spokesperson, minority leader. Beyond the talk, what are you doing? We only know so far of Andy Awuni and his civil society group that is in court now and seeking to seek for clearer, or as it were, a lot more openness in the transaction.
No, first of all, we are giving the president the benefit of the doubt. He has the authority to put the plug on it, like what happened in
Is that the charge of the minorities to the president?
Of course.
That the president should come into this matter?
No, he needs to put a plug on it immediately. Remember the first round matter. The NDC, not the NDC, his appointees and the government spokespeople, and I was even telling that he himself all came out. So, the president, because he so loves Ghana, he had put a plug on it. This is even the time he needs to act and act now. So, if the president refuses, because he should be the number one citizen acting in the interest of this nation. And of course, we know that Andy Awuni and his company, his group have already sent this matter to court. The minority will act very swiftly on this particular matter. But we believe
when you say you act swiftly, what do you mean?
We believe, because I had a debate with the second deputy minority chief whip, Ibrahim, the MP for time, majority. And he actually said the president is going to put a plug on this particular matter. And that the president is totally against this particular sale. And I'm quoting him. He said it. He
said it on the floor of the House.
Not on the floor. We had an encounter, just like how we are on this.
So it's like a privileged information.
Very privileged information.
It's supposed to be private information.
It's not private, because once you are a leader in Parliament and you come out to say, well, the president is against this sale, and that the president will put a plug on it, we assume from our side that our appeal to him to step in as the chief executive of this station and stop this particular matter, it was being.
Well, if he's listening, he has the opportunity to come on and to say whether or not what you're saying is right. Now, Abdul Malik, we have heard subsequently that even when the Center for Freedom and Accuracy and the Awini's group went to court the last time. You had KB Asante, retired diplomat, the distinguished statesman, say a few things. He had gone to find out for himself what was going on and said that as a contributor to SNIT, he felt it was important for him to have a lot more information. Do you have a sense of feel that the transaction is being shrouded in any secrecy?
Well, I think last week we discussed this matter.
Right.
And the point I made was that I thought there was a need for greater transparency and more information flow from especially the Bank of Ghana and then, of course, the others. Come last week, some information came out. Bank of Ghana spoke. Fortis has also spoken. Some information has been put out there.
Fortis has only said that they would come out in due course. They haven't said anything beyond that.
Okay, but to be honest,
they have said that everything has been above board.
Yeah, that's what I'm saying. They haven't given any details. Even Bank of Ghana, there was some deficit with what they said. So my stand really is that this deal should be put on hold. I said so last week, and I want to repeat myself. I was hoping the court would have granted the injunction that Awini's group was seeking.
It's not been moved.
But I'm told they've given adjourned there.
Yeah, it's not been moved because the lawyers for SNIT were short-served. They need some sufficient time to be served, and then they would have the opportunity to also respond.
Yes, I'm hoping things will be fast-tracked so as to hold it. We should hold it and seek more answers. I think there are questions that we need to answer. Of course, I made my point clear here. I disagree with those who are, and I hope that's not what NITU was doing, who are restricting themselves to just the bid prices and doing a certain comparative thing relative to which percentage you are getting.
But you agree it's part of it.
Yeah, but if it stands on its own, it has no significance.
Dr. Wampa is reported to have said that the Bank of Ghana did not depend on whether the transaction is profitable, since according to him, Fortis has the capital and the pedigree to change the fortunes of merchant banks.
I don't know
what's their capital
and the pedigree. That's what we need. We need to know. You see, it's like this, and I raised it here. It's like the Vodafone thing. I recall the Doa Jaho in Parliament raised the point about Telecom South Africa having come with a bigger, higher price bid. And so he didn't understand why government had negotiated a deal with Vodafone. And explanations were given. And truly, there was no way you can compare Telecom South Africa with Vodafone based on its global competitiveness, its technological capacity and all the rest. So it's not just the price. And that's the point I was making, that why is that it's important to look at. If you isolate it and overrate it, you'll be creating problems. And to that extent, I disagree with those who are pushing it. The same thing happened with Vodafone divestiture, and we explained ourselves. So I want to remain consistent on that point. But we need more info. And so I don't think the deal should be allowed to go through at this stage. That's the way I see things. The point about UMP, I was the one who made that disclosure.
Right.
And it's true that there had been an earlier search commitment we didn't go through because the Access Bank took over Intercontinental Bank. And Access Bank wanted a situation where they would study the proposals, get a board approval before they committed themselves, which I'm told on 13th November happened. And by December 15th, it is hoping, CMP is hoping to pay. I mean, I believe we should wait and see if it happens or not. But I'm not too sure whether the EMP had not serviced its debt since 2009. I'm not too sure about that. No, the documents I have show different. This is sometimes it's not good to come and do all sorts of disclosures on some of these businesses and their relationship with banks. There's sometimes an element of confidentiality and things. So if you are not careful, you can create some problems. And that's why I'm a bit hesitant in making some disclosures, because I have figures that were paid 2009 and 2010. But you see, bottom line, and I have to be very frank about this, the loan that Ghana Commercial Bank and Merchant Bank jointly gave to UNB was given to them in 2007. It had a tenure of 60 months, meaning that it was to end 2012. By 8, that is 2008, October, Merchant Bank, without consulting Ghana Commercial Bank, actually varied the terms from 60 months to 36 months. Now, the 60 months, UMP were paying 750,000 monthly to service the debt. The very moment it was varied, they had to pay 2.5 million monthly. Obviously, the company complained that it started having cash flow difficulties. Ask yourself, on what basis was that variation done?
Right.
By whom and on what basis? And why unilaterally? All these things created that cash flow problems for the EMP. But as far as I know, they service the debts to some extent, not the way it should have been done. So they are hugely indebted, there's no doubt about it, and they ought to pay, and they are making arrangements to pay. I have a difficulty when EMP is singled out because of his brother being president, that is Ibrahim Muhammad's brother being the president. I have a difficulty. I restrain myself from doing similar things because I have a long list of the debtors, a long list, okay? And there are prominent politicians, businessmen, and professionals. Some who belong to the other political divide. Some who even belong to my own party. Some who belong to Nitiwu's party. Very prominent names who also owe and who haven't serviced their debts to for a long time.
In that regard, what do you say to KB Asante? And he's reported to have said retired diplomat KB Asante has called for the heads of the directors of Merchant Bank whose actions or inactions have led to the seeming collapse of the bank. He said a bank which held a lot of promise and was hitherto the beacon of Ghana's economic development should not be allowed to collapse, while directors walk without blame. Instead of accusing political heads, KB Asante insists the directors of the bank must be held directly responsible for the sorry state of the bank.
They were appointed on basis of certain contract or some conditions of service and some agreements. They were appointed so. If they haven't fulfilled those things, and indeed, if there is element of criminality or corruption of some sort, why? The laws are there. They can be activated as far as I'm concerned. So I don't have a problem in principle with what he's calling, but it should be put in context. Do factual investigations relative to their contract of employment, conditions of service, and what they're supposed to do and not do. And if they violated any of those things, fair deal. Let the law take its course.
What has happened to the bank?
But let me tell you something.
Did not happen suddenly. It's happened
but
over time.
It still hasn't changed the point.
And who was watching?
It hasn't changed the point I'm making. There was a board of directors, there was management, and there was a government. So all those things can be put together and a decision taken. But I have also checked, and look, whether the debts are paid or not, there are people who think that that bank would still need some recapitalization going forward in terms of technology, in terms of expertise, in terms of the competitiveness of that industry. So I have spoken to some people who are against this Fortis deal and who says that, look, but we are not against recapitalization. We are not against getting a strategic investor to come on board. It is the lack of transparency that they are against. So really, going forward, in terms of the modern banking system, whether all the debts, even when all the debts are cleared, that bank will still need to up its technology and its systems and its personnel.
Interesting. Abdul Malik Kukubako and his inputs on that issue. We've got a bit of time extended for the show so that we'll be able to exhaust these matters. If you can respond directly to the minority, it's a deputy,
sure.
Leader is saying that their main charge is at the president. That's because of the involvement of his brother's company, which is being seen as owing a large chunk of the debt, and all that is going on, he should just stop it. He should intervene and stop the sale.
Well, I think that it is important to put things into perspective. But I must say that it is a very unfair call on the president. Quite clearly, we have institutions in this country. And if part of our current effort is to ensure that we strengthen them and to allow them to work, then I think it would be out of place to ask the president to intervene on this basis that there is some level of conflict of interest. I mean, I was so happy when Kweku Baku stated in a very polite way, dismissing the claims being made by some members of the minority that, the president's brother, in terms of being one of the, his company at least, being one of the customers.
On this occasion, you are delighted and you agree with him.
Because it's the truth. Okay. It is very clearly the truth. I mean, first of all, he did not, if you like, negotiate that loan with the bank when his brother was president. Second of all, it is a total myth and a rumor that he's not servicing his loan. And so these are very important revelations. And third of all, it is not only Ibrahim Mahama who is indebted to the bank. And I would have hoped that Kweku Baku would have gone through the list.
As a matter of principle, I'm against
He
that.
would have gone through the list so that we would put this issue to rest and deal with it for what it is, rather than this attempt to make it a partisan football game as usual. So I totally disagree with the call that the president should be involved. But be as it may, I think that we should not dismiss the role of the central bank, and we shouldn't needlessly question the motives and the ability of the central bank to do its job. If we have any reason to question the lack of information in the public domain with regards to how this came to be, the right place is to go to the court of law and seek redress. And so some of us, rather than calling on the president, we should be looking at the components of our system which allow us as individuals and indeed entities to seek proper redress. So that is where I disagree with the minority.
He seems to suggest, that there's a precedent where the president has stepped in before, so why not? We should do it again.
I don't have any facts to that effect. He's making allusions to a statement made by a colleague member of parliament. It is possible that he was also pulling what can now be described as a KT Hammond, where if he was before a commission to make a statement based on swearing an oath, he may not say what he said. So I don't want to give that.
Okay, I'm going to get you guys. I'm going to get you guys to swear an oath when you come on the show.
So I don't think that it is fair to ask the president to intervene for obvious reasons. We must move away from personalizing these types of matters and allow our systems to look at them. And wherever the chips may fall, so be it. That is what I will have to say on this matter.
No, Samson, let me just say one thing, and then I think he needs. You see, what he's not getting is, I mentioned three things. The first thing is the fact that the lawyer for the president himself is the same lawyer for his brother's company, is the same lawyer for the company seeking to buy Merchant Bank is involved. The second thing is the fact that the brother is the highest debtor, and I'm not seeking to blame the fact the fact that because the brother is the highest debtor, we are against it. No, we said that morally, and for his own image, he should really assess that particular matter, because when Fortis buys it, Fortis says we can only be able to recover 30%. And the last point is that we all know the directors of Fortis. There's wind blowing, and we know who they are, and they are all NDC. They are your party people, so you should be very careful. You should just oppose all these things and then put a stop to it. Get all the information.
You're not saying NDC people should not do business.
Oh, I didn't say that. And that's why I said that. Because of all the making things around it, they should put a plug on it. Give us the information. What's the background? Fortis, how much capital do they have?
You brought in the political color, that they are all NDC.
Yes, I know,
but you
that's
know
true.
That should not be material.
I know, I concede on that one. I accept. Okay. But I'm just telling him, how much do they have? Who are the investors backing them? How much do they have? How much are they bringing? How can we risk a bank just hand over to people and we don't have any information about it?
First of all,
he's rehearsing what he's already told you.
First of all,
the moral question.
The lawyer is a private legal practitioner,
right?
And he has the right to offer his services as he wants.
Seeks them.
So I really don't think that should be made an issue. Second of all, it's important to note that First Rand was not ready to take the liability. whereas we know that Fortis
that's not exactly
prepared,
true.
Who told you that?
There was a certain
It's not
structure.
true.
That's
Well,
not exactly true.
Well,
There's
first
a-
of
it's
all,
not true.
Fortis
They were going
is
to
a
appoint
local.
an independent,
It's not true.
independent entity.
Fair.
Matt,
Fair.
they're known as Matt. I
Fair.
have a copy. That's
Fair.
where the
But it
full
is a
list of
local
the
group.
debtors are.
And what has happened to our call to get Ghanaians involved? I mean, look at the number of banks that we have in this country.
Okay.
How many of them are indigenous? Why can't we support our own?
So how
to
much
do
does
what
Fortis
is right?
have? How much do they have? What's their capital base? Who are
Have they not been able to
okay, gentlemen,
demonstrate and to satisfy the conditions?
Gentlemen, thank you. Let me now go to Mr. Bochi. May I know from you what, for example, you will be seeking if you agree that there's a need for a lot more sunshine on this whole transaction? What would you like to see?
Well, before I address that, I think Kweku had a little concern. I'm not sure he was asking for answers, but I can volunteer one. The one on the application for injunction.
Right.
Yeah.
That you wish it moved early. The principle of law is that one, you have an application for injunction pending, and it's brought to the attention of the other side. No further action can be taken.
Really?
Until the application is heard. So at this stage, no action which is prejudicial to the claim involved in the application can be taken. Anybody who does that is in contempt of court. So for now, there's almost an injunction as we speak.
In effect.
Until the application is declined.
But there are some authorities that suggest that, I mean, this is based on, good faith, really, and that, contempt in that respect might not be...
No, it is. It is. When the application is served on you, and you have noticed, like they do have notice, which is very interesting because coincidentally on that day when the application was supposed to be moved, I was in court.
Right.
But I was in court on another matter.
Right.
And I didn't even know it was in that court. So it was when I got there and I realized the crowd and everything, and I saw the very senior diplomat, KD Asante himself walking. I was wondering what frankly must be in court today. And that's when I realized that the application was meant to be moved on that day. So clearly, by the lawyers showing up in court, there's an indication that, short-served or otherwise, they have notice of the application.
Right.
No action can be taken which is prejudicial to the claim involved in the application until and unless the application is heard and or declined. If it's granted, of course, then there's full injunction. If it's not granted, then at that stage, whatever you want to do.
I hope the Bank of Ghana has a legal department and they are aware of this.
Oh, I'm sure they certainly are aware of it. So just to address, I'm sure there are people who probably are concerned in that regard, and I thought it's important to clarify. But the second thing I just want to mention in respect to your question is we must understand that Merchant Bank is a company.
Right.
Therefore, it's regulated. It's not a statutory company. So it's regulated by the Companies Act. The Companies Act has one fundamental objective for all companies, the protection of a company in a transaction like this, i.e. acquisition. The company being acquired must be protected in all shape and form. The question we ask ourselves is whether in this particular circumstance the company is being protected. Again, we have varied information. People will say varied things. The Bank of Ghana is the regulator. The Bank of Ghana is the institution charged to do this. I can only hope that the Bank of Ghana indeed is making considerations of all these things. It seems to me that the issues involved, among others, the question of the bad debts. I'm not sure we can even call it bad debts at this stage, but the question of debts, the monumental debts on the books, what happens to those debts? Assuming some go bad, and some may go bad, but assuming some go bad, who takes them? Now, typically in the case of acquisition of companies, the one acquiring, if he's trying to avoid debt payment, it is one of the considerations that may go into whether or not indeed we should sell the company to you. Because it's a question of debt and liability. And he just typically would not want to come and say, I'm not taking. Usually companies may not acquire others because of bad debt or because they are very bad, their books are not looking good or healthy. That's something I'm sure the bank is probably considering. But the question of investment also, and Kweku was mentioning the recapitalization. How much is who bringing as far as this company is concerned? Because the company is a distressed company, there must be an exit strategy as far as the distress is concerned. Who is going to capitalize or recapitalize this company? And among others, the question of leakages. Why did we get to where we got to? And how do we ensure that we don't get here again? So what is the strategic movement moving forward?
Right. So let me inform those of you who are listening on radio that unfortunately we have an extension. We have 30 minutes more to finish the other matters that we have. Unfortunately, you cannot continue to listen. So you have to tap in, get to your TV set, or go online, multi-TV world /streams, and you can continue to enjoy the rest of the show. Now listen to this, Mr. Abuchi, and this texter says that what concerns me above all in this merchant bank deal is that the main shareholder is SNIT, the custodian of the workers' pensions. SNIT's investment decisions are poor and return very little value to contributors. Secondly, we don't care whether the debtors are NDC or NPP. Where is their collateral? For heaven's sake, seize them, sell them, and let poor workers have their money back.
Okay, so I was going to tie that into the issue of corporate governance. But the issues I've listed, I'm not the Bank of Ghana, I have no competence or expertise in that area. I trust that people who are there have all the capacity to do what they have to do. But one would expect that these are considerations the bank would have already made by now. Hopefully they would have done that. But the reason I suspect we have all this confusion is probably because of the way the corporate governance process has been managed, or rather mismanaged, which is what has created this. The merchant bank is not a typical company. It's a company, but it's not a typical company because of the shareholding structure. If the merchant bank was a regular company with regular shareholders, the shareholders would have had to be briefed on this. Now, you and I are collateral shareholders of the merchant bank because government is a shareholder, because SNIT is a shareholder, and because we have a statutory shareholding in SNIT by reason of our contributions and citizenship, among others, we are collateral shareholders as far as the merchant bank is concerned. What it means is that for a major transaction like an acquisition of the merchant bank, which would then change fundamentally its character and its independence, among others, we may not even know it as we know it today. It may not be called the merchant bank from today, from any time it's acquired. It means that the shareholders should have been properly consulted. In the process of shareholder consultation, we needed to have been given all these things I itemized and all of us have spoken about in advance. I think that there has been too much reaction to too many things, and that is part of the problem. So the question we're asking at this point, among others, among all these issues that have been itemized, is between all the various bidders, why is this particular company chosen? At this stage, we are getting all kinds of information, but it seems that this should have been a bit proactively done and probably wouldn't have gotten to where we've gotten to. The issue of the preference for 40s, and APAC indicated that we should prefer one of our own. I think it's excellent. It's a brilliant idea. But if you deal with the issue of the relief from debt and the distress, and the strategy to get us out of that place, and the question of the potential bad debts, and assuming indeed they are bad debts, whether it will become a liability for the taxpayer ultimately, all these are considerations which probably we should have been properly informed of once there was a decision made to go with 40s. Yeah. And I think it should have been a public announcement because we are the shareholders ultimately. SNIT & Co are trustees for us. They are holding shares on our behalf because ultimately they do account to government. I think it is symptomatic of a major breakdown of corporate governance in Ghana. Merchant Bank, again, I come back to the general as opposed to the particular. Merchant Bank is probably just a picture of the shareholder, of the corporate governance problem. Who are the directors? Why did we get to where we've gotten to? Banks are in the business of getting bad debts, no doubt about that. But if you have a major bad debt on your books, by reason of which there must be an acquisition. So we need to ask the question, what is the major motivation for the acquisition? If it's the bad debt, then if it's a bad debt, then the question is, why did we get to where we've gotten to? Is it an issue of the corporate governance incompetence, i.e. the board incompetence, the managerial incompetence, or it's a matter of collusion? These are issues I'm sure we're not even dealing with yet. We are just choosing between, bidders, and this one is good, that one is bad, and I agree with you. I am not in that area, but I can certainly be sure, and I agree with you, that it's not just a consideration of who is bringing the bigger bid. It's a global, a number of issues are considered, and that one I agree. But we need to ask ourselves, why have we gotten to where we've gotten to? And if we are selling one to the other, how guaranteed are we that we're not going to get back to this point? And who are the directors, and are they going to get off the managerial issues as far as the new company is concerned? And the ones coming in, do we even know who they are? And how tested are they to ensure that we don't get to where we've gotten to? Because there's a public interest as far as the merchant bank is concerned, and it's not just a regular company. And I think that we should again look at the broader issue because there may be other merchant banks in the pipeline, and I don't want us to just
and you will not subscribe to the minorities charge to the president?
No, I think that, again, let's face it, presidents will come, presidents will go. They have families, they have relations, they have all kinds of people who should live their normal lives, not because the president is there. Sometimes the reason you respond to things is because of perceptions and you want to deal with perceptions. The problem with perceptions is that however erroneous they are, they create an issue of trust and an issue of responsibility. And for a president, sometimes you just want to make one statement to clear issues. I'm not sure whether at this stage, probably he wants to speak to the issue and to further put pressure as far as the entire process is concerned. The matter is in court. That matter being in court on its own creates an issue of responsibility the president has to be careful about. I think in the circumstances, probably we may want to say that he should hold on until the court matter is disposed of, and then probably can make a statement, so that it doesn't appear as if he's also putting pressure and further creating more murky circumstances as we have.
All right.
But something, you remember that UT put in a bid. UT is a Ghanaian. Yes, UT put in a bid. UT is a Ghanaian wholly owned bank, just like what he said. And I can tell you that the UT bid was better than the Fortis bid.
But no disclosure yet.
But that's only one.
It means we need the information.
So that is why the Bank of Ghana, through Dr. Wampa, should have disclosed all information.
I agree.
You see, for me, it's unfair for him to have said the minority or other people do not know what they are talking about.
What are the details of this UT bid that you know that you say is better than Fortis?
First of all, it's a higher bid. It has capacity also in terms of the banking industry because it has, of course, a history. You know, it has experience. Fortis,
that argument, there are those who say don't make that argument because you don't need to have experience to take a banking, business.
Unfortunately, you do. You remember, let me tell you something. You can form a company
when you have
today.
Money, you can hire
you can form a company today for the purpose of acquiring another company. So that one we all understand. But I can tell you that you need experience. It is when you are selling a public company, you are selling it to ensure that you do not go back to where you came from. And so the first option is always to ensure that if there is in the competition somebody who has more experience, who has a bigger capacity, and who obviously has, in terms of assets, bigger capacity to be able to pump in more money, you give it to that person.
It's a very weak argument.
When you bring in,
are assuming all things are going to be equal.
When you bring in,
we don't have any information. So
when you bring in the shareholders of Fortis being people belonging to this particular the governing party, is that your suspicion? Why you think UT has not gotten it?
I do not want. That's why I do not want, obviously, to conclude. I do not want to conclude.
Serious question.
Okay, I'm very careful that I don't want to conclude too early. But I'm saying that if you look at the shareholders and you look at their assets base, okay, and you compare to other competitors, their list, unless there are other strategic investors that we don't know about. Okay, I look at their shareholders, I look at their assets base, I look at all of them, and I look at their competitors. They were the list. And so I do not, unless we have some other strategic investors.
But is this a strategic investment?
But we don't know. We don't know the people.
I kept asking. I'm asking because I realize you keep repeating strategic investors. Because my understanding of strategic investment here will be someone who's actually bringing in capitalization without necessarily acquiring you.
No, I understand.
But if they're acquiring, then they are becoming a new company.
No, you are not getting me. I'm saying that if there are strategic investors that Fortis has contacted to do that, after they have acquired, that we don't know about. And that's why I'm saying that Dr. Wampa should be careful how he labels people, because himself, after investing our oil resources and returning nothing, he should be careful. Because if he takes on the minority and we go on, he'll be very, very sad.
So are you threatening him?
I'm not threatening you. I'm just telling him.
Exactly
he'll be very, very sad. But I'm saying that we need more information. Seriously. Serious information. And that's why I thought that if the president, for the sake of the nation, and for the sake of himself, because trust me, if this deal goes through the way it is, it will hang on his neck for a long time to come, even when he's out of office. I'm telling you.
My very final question to you, and straight, direct and short. You have concluded as a minority, and I asked this question of your colleague the other day, that this is fraudulent. From what you are saying, there's no basis to make that conclusion. You have suspicions.
There is every basis to make that suspicion. Why would anybody want to dispose of a public asset in all intents and purposes, to the least bidder, to the man with the lowest assets base, to the person with least experience, and you think that somebody will not label that as fraudulent? Of all the competitors, he has the least assets base, he has no experience in that capacity, and as well as the fact that politically we know that the directors are linked. Why would somebody not say that it's fraudulent?
I've just told you about this argument of experience not being, that important. You still, go by that.
Well,
that
for
argument?
my studies in company law at the master's level, I can tell you it's very important. Seriously, it is very important.
I see.
And I disagree with him.
But I'm not sure. I'm not sure you quoted me right.
Yeah, I'm not quoting you rightly.
No, I didn't say it's not important at all. I didn't speak of experience. On the contrary, actually, I think experience matters because pedigree. And I think you said the Bank of Ghana mentioned that.
Yeah.
The question of pedigree is vital because you are going to rescue a company which is in distress, and you must show a pedigree in rescue in this particular area. And so, if you haven't shown that you have had something to, it's not fatal. But if someone has that over you, it might edge you out. Yeah. So if you don't have it, it doesn't mean you can't do it.
If I can prove that I have the money to buy the expertise to do what you require.
In other words, if our capacities are equal and I have pedigree you don't have, I have to edge you out.
I see.
Yes.
Very, very interesting. You're still here on Newsfile, and you're watching us on your Joy News channel. We have some 20 minutes to get out of this studio. We have two other key important issues to look at. I'd like to start with this one with Dominic Nitiwu, and not the minority in Parliament. In this regard, it was really about the committee, the Parliament Select Committee on Health, that made that intervention. They called for a ceasefire in the tussle between the FDA, that's the Food and Drugs Regulator, and Tobinco Pharmaceutical, that's a pharmaceutical giant in this country. And you probably may be aware of the problems that they have had to go through in the last few weeks in this country. They have gone to court, come out, and all of that about fake drugs. The question that is to be asked is, why is Parliament interested in this? There is the body, the FDA, that is empowered to ensure that the drugs that get to us are safe. And they say these drugs are fake. The Tobinco is challenging and saying that you cannot say fake because, technically the law does not talk about fake. So you should only be talking about drugs that may not have passed through your testing, but don't call them fake.
No, first of all, this is not the first time something like this has happened all over the world. We've always had pharmaceutical companies that, for some reason, may have one or two drugs that somebody will call fake because they have not passed through the testing period. There was a mixture of some drugs, and then it may not have been tested. So what you do, if you are the regulator, like the FDA, is to ban that particular aspect. And if you think there was criminality, you arrest the directors, that the people, and charge them to court and let the court decide. But where a Ghanaian company with Ghanaian workers, thousands of them, and every day there's tussle between the company and the FDA, it's not good for the image of this country. Seriously. It's not good for investment climate. It's not good for the image of this country. It's not good for us as a people. So a representation was made to Parliament by the company that please step in and let's get to know the facts of the matter because you represent the people. There are thousands of Ghanaians who have been employed, who will be thrown onto the streets. We are praying to God on the vigil and appealing to the president and praying that some way, somehow, this problem is solved. And we think that as Parliament, you would be able to look at it. In fact, they came to leadership of Parliament as well. Of course, I spoke to them and some other leadership spoke to them. But luckily for us, the Committee on Health, Regulator and Dr. Nani, the chairman and the ranking, we felt that it was easier to deal with that particular matter through the committee level. Because Parliament can investigate into any matter they so wish.
You're saying that they should give Tobinco a moratorium of about at least 3 months. And what should that do?
No, first of all, what the committee wanted to do...
Let me read here. You say in the press statement issued by Parliament, that committee, it recommended that the FDA should consider granting a moratorium of at least 3 months to all affected manufacturers and importers of food, medicines, and herbal preparations and medical devices that, according to it, would bring their products into compliance immediately as required under the Public Health Act 2012.
What Parliament said is very clear, that we are not in the business of helping to close down companies or throwing people out into the streets. That's not what Parliament is interested in. If you believe that those drugs are on the market and they are not safe, withdraw all of them and test them within the 3 months period. If the efficacy or the drug is good enough, then you can pass it. But if you behave in a way that seems to suggest that your idea is to harass maybe a particular company, or maybe try to close the company or let them go down, then Parliament itself is not interested. So Parliament was not interested in who was right, who was wrong. We are not to judge. Parliament was interested in calming down tempers, looking at the matter dispassionately, not political, and finding out what is it that we can do to help the situation. And the best way was to look at it, give them 3 months, let them bring in the drugs, test them. If the drugs are good for the people, you allow them to sell. If the drugs are not good, you ban them. Because Tobinco brings in well over 100 different categories of drugs. As speaking now, I'm aware that one of the representations they made is that they had so many tens of containers sitting down at the port there, and they've been seized. Their warehouses have been seized. So we are saying that, test them well. If they are good for the people, that's it. Your aim is not to punish them. Your aim is not to collapse the company. Your aim is to ensure that the right thing is done, and that every drug that we take, whether it's from Tobinco or any other company, chemist, is good for us. And so that's what Parliament tried to do, so that they could solve the problem. Otherwise, let me say something. Otherwise, tomorrow, if we are setting an example, it could come to backfire on us. Because nobody would invest in this country. No individual will invest if people feel that they cannot be protected by the laws or by the courts or by the state of this nation.
Dr. Park, how do you feel about Parliament's intervention and this call when the ordinary Ghanaian is looking up to the FDA to crack the whip, so to speak? So if it finds that Tobinco Pharmaceuticals has drugs on the market which have not gone through what they call the clinical trials, even in India, where they are coming from, and have not been licensed or certified in Ghana, and yet they are out there and they cannot vouch for their safety, they should crack the whip. If people are supposed to be prosecuted for some criminal offenses, they should take them on. Why should Parliament come into all of this?
Well, Samson, you've hit the nail right on the head. Ideally, we can all expect or anticipate and hope that the right institutions, in this case the Food and Drugs Authority, would be allowed to do its work. It has the primary responsibility of ensuring that medicines which come into the country clearly are not fake, and they meet the requisite standards to ensure that when applied or when we use them, their efficacy can be trusted. So ideally, I don't think that anyone should fault the Food and Drugs Authority for executing its mandate. Very clear. And I think that whilst one can perhaps appreciate why the Parliamentary Subcommittee on Health may have taken an interest in this, we must also be very careful in terms of not creating an avenue that would perhaps encourage wrongdoing. And that is perhaps where my concern is. Because how many times are we going to do these kinds of interventions when there is clear basis for the recognized state institutions to act? Are we, by this, not undermining the ability and authority of a public institution? Are we, by this, not also emboldening entities which should do the right thing and know they should do the right thing, and for whatever reason they don't do the right thing? So it is a double-edged sword. But I think that the precedent, may be a bit worrisome if we begin to see a trend like this continuing. I mean, one may even ask a lot of other questions. Is this going to be the first time that the FDA has stepped in to take action like this against a company? Why is it that in this particular case of Tobinco, the parliamentary subcommittee has deemed it fit to step in? So it raises a lot of nuanced questions that will require us to think very deeply about. But
there are concerns about a lot of workers that might be laid off or who may lose their jobs if things don't go on well and Tobinco, Tobinco's business is affected.
Well and good is a fair point. But are we also saying that we should allow fake drugs or drugs that have no efficacy to, saturate our system? Have we thought about the number of people who may die or who may suffer irreparable damage as a result of this? So, yes, it's an opportunity cost, but I would think that we should err on the side of caution. If there is reasonable grounds for the Food and Drugs Board to do what it is doing, I really don't see why we should try to intervene. But as I said, it's a very delicate balance. I can appreciate the position that the parliamentary subcommittee is coming from, but we should not do anything that would undermine the work of our state institutions. I mean, we have come back to the same big issue again of allowing institutions to do their job and let the acts.
Unfortunately, yourself, you have had to lead a task force to do a job
exactly
that otherwise should have been done by some other entities.
Well, that is
and
true.
You are retrieving money to the state.
We are, and I'm very happy to indicate that the dividend, once we collate all the information, will be something that Ghanaians will be very proud of.
Right. Abdul Malik, certainly we shouldn't wait and ask. I've been thinking, I'm saying, this drug is already on the market. Is there a single report of someone taking it and having any effects? But you don't want to wait to have that before you step in. What do you say to this process?
When it comes to public health, I think the principle is clear, non-negotiable. We must secure and ensure public health. Right. I would not compromise on that. But the conduct of operations in terms of the regulatory authority must also be in line with law and procedure. I sit somewhere, I've been looking at this whole thing. It's like, is it degenerating into a certain Rambo-style movie? People talking left, right, center, arguments left, right, center, Rambo actions here and there. I said, come on, we're better than this. Who could effect the prescription for whatever mischief exists out there with finesse? And if indeed we have the evidence that this is the mischief, the laws are there. So when you are doing that, then everybody will come on board. Because as for public health, we will not negotiate on that. But ask me whether I'm convinced indeed whether there is any evidence that something's gone wrong, and so this is what has gone wrong, and we are curing it. As I sit here with all my investigative abilities, I'm confused.
You side with those
Today,
who suggest that,
tomorrow, that.
Who suggest that if something indeed had gone wrong, if the FDA should have been in court prosecuting somebody.
The laws are they are empowered to so do. I hear then later I'll hear Ministry of Health and FDA cry having problems. I said, goodness, what is this organized chaos? What's going on there? Okay, so there must be something. I see sometimes clash of egos. I see sometimes a pursuit of personal interest. The whole thing is mixed up. Basa. Confucianaya basa. It's incredible. Ghana, such straightforward, serious issue. Look at how we are tackling it. So we don't even know who is right, who is wrong. Where is the law? Where are the institutions? So Parliament must intervene. Look, I think that we need to look at this thing critically. I believe there is something happening that may not be in line with the law. I don't have the answer yet, so I don't want to speculate unduly. But I think somebody is flexing his muscles. Because if you have to flex your muscles according to law, the evidence must be available. Proceed immediately to the appropriate forum. Operationalize the law and deal with it. And look, you will get 100% support. Because for all you know, my child could be a victim. So I would not compromise when it comes to public health. Right. But I want to be convinced that indeed there is mischief out there. And also I want to be convinced that the methods being applied are in line with the law as mandated by whatever statute is there. So, but right now I'm not confused. Okay. I'm not convinced. I'm rather confused.
All right, you're still here on the news file. Thank you very much for keeping your dials with us here on Joy News Channel. And I'll come to you, Mr. Buchi, now. And you may certainly would have been observing and looking at things with a legal eye. What do you think should be the way forward? Should it be the Parliament's intervention, asking for a moratorium and allowing those who may have defaulted to come and comply with certification processes? Or, like Kweku is saying, if you really have the evidence that they have not complied, you ought to be prosecuting them and not to be heard on radio debating them?
Absolutely. I totally associate myself with what Kweku said. I am also a bit perplexed at the fact that we are not in court, we are not applying the law, but we are arguing. I mean, once a regulator starts arguing with the regulated, then you know the regulator has lost control. I mean, you don't argue at all. You make orders, and the orders you make them through courts. You go to court, you get a court, you secure a court order, and you get things done. We don't have to get to the point.
I think they had initially slapped a fine of some, is it 40 million, thousand or million Ghana cedis, 1,000 Ghana cedis, and they paid. Right,
you can, I mean, the powers of fines, the penalties, all these things are still subject to court, because you may have these things imposed and you may have the regulators still not complying, and you have to go to court and secure something. Right. Because that's where the punishment properly can come in the event of default. Parliament cannot compel them to do what they have to do. What Parliament can do is to urge, and I suspect that's what Parliament is doing. Parliament, I totally agree that Parliament is doing what they have to do, because as the Honourable Minority, Deputy Minority Leader is mentioned, clearly there are losses that a country can suffer in the event of either side losing out. The country suffers if the FDA, loses out by reason of its failure to enforce what it has to enforce. The country loses out if Tobinco's business suffers fundamentally, and you have people who are employed, going home. It's a daily bread business, and so for the people who are working there with potential losses, these are serious issues.
They have been organizing prayer meetings.
Right. So I think the issues involved are one that we can compromise. But it's amazing that we've gotten to where we've gotten to. Because as was mentioned earlier, this is not the first time the Standards Board, FDA, and all these regulators have gone out there against entities and companies and actually administering one form of penalty or the other. But we are where we are today because it can happen that there can be disagreement between the regulator and the regulated. And when that disagreement arises, the law caters for the way forward. We should simply apply it.
Right.
So the secular rigmarole, fashion of going about this is a bit of a difficult...
Run, man, run.
You are a journalist. Find out whether the head of the Indian company plus the Tobinco boss were arrested and why they were not taken to court.
Yes, that has also come up. All right.
It reminds me of an old movie. Run, man, run. Santana is in town.
I've got just about 3 minutes. I was hoping if I can get just about a minute or two of your thoughts on the Justice Databa panel that is going to probe the Vicky leaks in respect of the suggestion that the judgment of the Supreme Court in respect of the petition was compromised. They have been invited to come to the panel and to, be interrogated.
Well, again, it's an exercise in transparency. It's an exercise to see if we can remove a perceived blotch on something. I think it's a useful exercise. If you ask me to what end and what can it do, whatever the outcome is, assuming that in the worst case scenario, we actually do find the issues established, assuming that happens, we would have to still go through the processes of penalizing judges or persons involved. Unfortunately, it can't do anything about the judgment that has been given.
Yeah.
That is already gone. So for people's expectations...
I think the petitioners can't go for a judicial review?
No. You can't go for a judicial review on the basis of that. If you're going for judicial review, the basis for going for judicial review is clearly there. One of them is not on a judge compromising himself. Of course, you have to establish that probably if he has, that has affected the law that has been applied.
But is the time not gone? Lapsed?
The time might have been... right. The time is already...
That's by way of a strict appeal.
Correct.
In the Supreme Court as in a review.
I think for management, I just want people to have managed expectations. The expectations is the worst that can happen out of this is that a judge can actually lose his position through the process of removal if it's established and if the process is set in motion and indeed the process succeeds. That is the worst that can happen.
Okay,
You can't
this subcommittee.
of the
This subcommittee of the Judicial Council will do its job in camera.
Again, they can decide the modality of the work, but for purposes of transparency. But again, it's a very delicate thing. You know, the confidence in the judiciary,
right,
when erased, especially, and let's not forget, I really have to say this carefully, we are still not a country of majority literates. We're still a country with a lot of people who don't understand the issues.
Right.
And their perception, and with the politics, things get messed up.
Right.
We can easily destroy the image of this court, and it will take us decades to get it back. So I think, probably, and in that regard, let's see how it evolves as far as the camera component is concerned. Because
thank you very much. I'm sorry, gentlemen, but we have to end it here. My guests on the show have been Abdul Malik Wekubaku Jr., who is editor-in-chief of the New Crusading Guide newspaper. Dr. Clement Apak, he's a presidential staffer. Dominic Nitiwo, he is deputy minority leader of Ghana's parliament, and Ernest Kofi Abochi is a legal practitioner and a lecturer at the Gimpa School of Law School. I'm Samson Ladi Ayenini, your host. Thank you very much. The show was produced by Sedem Ofori, Emmanuel Ante, and of course Abubakar also in the background, making sure that you got all the footages coming in nicely. Have a good afternoon. Thank you very much.